ಆಯ್ತು ನನ್ನ ಇದರಲ್ಲಿ ಬರುತ್ತೆ. ಕೋಡ್ ಫುಲ್
ಸರ್ ನಮಸ್ಕಾರ. ಏನು ಲೇಟ್ ಆಗುತ್ತೋ?
Please wait. 2012. Srinivas.
Yes, my lord. My lord, the appellant has filed another appeal in MFA, my lord. They have said they are going to withdraw it today.
Who told you that?
Guru Prasad just called me. He is going to withdraw this appeal. His colleague is there, he says.
Gurudev Prasad. Nobody said I'll pass it over.
My,
ಯಾವ ಅಪೀಲ್ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ತಾರಂತೆ?
my lord, that first appeal, my lord.
First appeal ಅಂದ್ರೆ ನಾನು order
This
pass
360. Yes, my lord. Your lordship has passed the order, no? My lord, the first matter, that is 360/2020.
ಇನ್ನೊಂದು ಅಪೀಲ್ ಯಾವುದು?
ಇನ್ನೊಂದು 860/2020. My colleague is also there. She has bought the copy of order, which has been settled, my lord. We have deposited the order, compliance of the local settlement.
On 21st of September 2022. This appeal was disposed of after hearing the Senate Council. Over thereafter, memo was moved by the Council for the Insurer, stating that the appellant already filed MFA H-16/2020 when settled before the local. They submitted that the order passed in this appeal would not be sustained, it would not be correct. The matter could have been settled. The Council for the Appellant has filed a memo dated 26/9/2022 seeking for dismissal of this appeal as withdrawn. View of this memo, the order dated 21st of September 2022 is recalled and the appeal is dismissed as withdrawn.
Much obliged, my lord.
ಸಾರಿ ಮೇಲೆ
ಯಾಕೆ ಪ್ರಸಾದ್ ಅವ್ರು ಹೇಳಲಿಲ್ಲ ನಂಗೆ?
ಅಲ್ಲ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ, ನಮಗೂ ಇಂಟಿಮೇಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅವರು. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್. ಸಾರಿ, ವೆರಿ
ನನ್ನ ಹತ್ರ it will be difficult for me to accept ಮುಂದೆ.
ಕರೆಕ್ಟ್.
That's why, my lord, the insurance companies are not allotting the cases which were directed by the court, my lord.
Court notice has been served on the
was
insurance company. Court
not
notice has been served.
it was not
They remained
allotted.
absent. They could have intimated.
No, I'm more worried about the fact that how did our office miss this? I think there must be some way of verifying whether all of them are now computerized. The moment an NBC number is given, they should be able to tell us whether an appeal is filed or not. No matter what the lawyers do, I think we should also take some steps.
My lord, my submission is kindly be noted. This our directions, all directions matter, my lord. It is better to send back to the Lok Adalat, my lord, so that companies will be there and advocates will come.
Before the Lok Adalat, Srinivas, they are not interested in settlement. The moment we suggest something, all that they want is they want to postpone it by saying we need permission, we need this, we need that.
Yes,
They don't come to the Lok Adalat with an open mind for accepting whatever is suggested.
Correct, your lordship is also right.
I think that Lok Adalat is a way of ensuring that what they say will have to be accepted. I think that is improper. Asking the claimants to give up 1 year's interest because they're coming to Lok Adalat. You're
Yes,
actually asking them for an early disposal.
correct, my lord. Lord, that second matter, my lord, some other advocate has been engaged, and since it was not served, it was served and unrepresented. On the basis of the submission made, my elder brother, I agreed to get it disposed of. But my lord,
When? And I'll dispose it of. I will not even ask him to take notice. I'll pass the order. You have not filed wakalat before. So therefore, by way of courtesy, I had asked him to take notice. ನೋಡಿದಿರ ನೀವು? Have you seen the papers? Have you seen the order? ತೋರಿಸಿ ಅವ್ರು. ಬರೀ ಲಾಸ್ ಆಫ್ ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್ ಮಾತ್ರ ಮಾಡಿದ್ರೆ ಸಾಕ? On 21/9/2022, insurer had been served and it remained unrepresented. Shiki and Shins were directed to take notice and was permitted to file wakalat. Thereafter, the appeal was disposed of, awarding only the compensation towards loss of love and affection. Submission is being made that Shri Sonja has been interested in the matter by the insurer. Therefore, he may be permitted to file wakalat. Requested is permitted to file wakalat. The type by the income award has not awarded any sum towards loss of love and affection in respect of all the claimants. That was the matter. It is appropriate to award a sum of rupees 1,76,000. This 44,000 to each of the claimants, in addition to the amount already awarded to the claimant. To this extent, composition stands enhanced. The appeal is dismissed. Without appeal. 31/9/2022 is recorded.
Much obliged.
Issue this. She wanted to take notice for the insurance. Yes, sir. Can't hear you. ಏನ್ ಹೆಂಗ್ ಆಕ್ಸಿಡೆಂಟ್ ಹೆಂಗಾಯ್ತು? You think it's worth admitting? You think it's worth admitting? Do you think it is worth admitting? But such deposit. Seven to 30. As requested, notice to R2 dispense with. If you need a error, Shri Ravi Shankar will take notice for R1. Since R. Anil Kumar has entered appearance, Shri H. Shivaramu is permitted to retire. Who appears for the insurer? No insurance, huh? Shastrigal ready, na? You are for the owner. You deposit the compensation. Shastri is for the claimant.
Memo fired.
My lord.
Till number 15.
ಸಿರಿಮಹಾ ಅದ್ರಲ್ಲಿ ನಾನು R3ಗೆ ಮಗಳು ಆಕ್ಚುಲಿ ಇನ್ಶೂರೆನ್ಸ್ ಇಲ್ಲ, ಏನೋ ಒಂದು ಆರ್ಡರ್ ಆಗ್ಬೇಕಾಗ್ತದೆ. ಅವರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ಲ. ನಾನು ಮಗಳಿಗೆ ಮಾತ್ರ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಯಾರು
ಬೇರೆ ಜನ ಯಾರೋ ಹಾಕಿದ್ದಾರೆ. ಇದ್ರಲ್ಲಿ ಕಡಿಮೆ ಆಗ್ತದೆ, ಯಾಕಂದ್ರೆ ಲಾಸ್ ಟು ದ ಎಸ್ಟೇಟ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು, 1/3 ಡಿಡಕ್ಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. 1/3 ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, 50% ಮಾಡ್ಬೇಕು. ಆದ್ರೆ ಇನ್ಕಮ್ ಜಾಸ್ತಿ ತಗೊಳ್ಬೇಕಾಗ್ತದೆ. ಎಲ್ಲ ಅಷ್ಟಕ್ಕೆ ಬಂದ್ ನಿಲ್ತದೆ ಕಾಣ್ತದೆ. 2054 years.
ನೀವು ಕ್ಲೈಮೆಂಟ್ಗ
claimant before the trial court I arrived as R3 ಅಂದ್ರೆ ಮಗಳು 2 ಜನ ಗಂಡು ಮಕ್ಕಳು ಪೆಟಿಷನರು I made as R3 ಮಗಳಿಗೆ.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಇನ್ಕಮ್?
Income 7,500 2014
2014 8,500
8,500 ಆಗುತ್ತೆ.
ವಯಸ್ಸು ಎಷ್ಟು?
54 years 11 multiplied, that is 10% added.
The claimants are the children,
Major sons and married daughter.
What is there to show that he is not age 54? Voter ID card is not actually issued on the basis of any birth certificate, any proof.
PML ಎಷ್ಟಿದೆಯೋ ಅದ್ರ ತಗೊಳ್ಳೋದು ಒಳ್ಳೆಯದು. PML 54 ಅಂತಿದೆ.
Oh, if he's 74, then when did he have the children according to you? If he's 74, did he have children at the age of 44? What are they doing?
ಮೇಜರ್ ಚಿಲ್ಡ್ರನ್ ಸನ್ಸ್ 30 ಮತ್ತು 28 ವರ್ಷನವರು.
54 I think is PM report ಎಷ್ಟಿದೆ?
54 ಇದೆ. That is found in page number 9, line number 7.
Accept the PM report. Doctors would know the moment they see the body as to how old the body is. If you can show something else. I saw, but how do you know how the ID cards are given, right? I don't think. ನೀವಾರು ಕರೆಕ್ಟ್ ಹೇಳಕ್ಕಾಗತ್ತೆ ಶಾಸ್ತ್ರಿಗಳ ಏಜು?
ಅದೇನ ಕಾಂಪ್ರಮೈಸ್ ಹೇಳ್ತಿದ್ರಪ್ಪ ಅಂತ ಅಷ್ಟು ಇದು ಮಾಡಿ
ಡಿಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ, ಸೊ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳಲ್ಲ.
ಇಲ್ಲ ಡಿಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ. 54 ನನಗೆ ತಿಳಿದ ಮಟ್ಟ 54 ಏಜ್ 54% PML
is the total amount due according to the award?
8,04,598.
This is of the year 2015.
ಮತ್ತೆ 80,000 ಜಾಸ್ತಿ.
They will not be able to recover. It will be a paper decree. I'll dismiss the appeal. Will you agree if you were in their side? If you come out with a reasonable offer and ask Shastri to consider it and dispose it. But 2-3 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಸ್ವಲ್ಪ. As of today, what is the amount due?
ಏನಾದ್ರೂ ಹಾಸನದ್ದು ಸಮಯದಲ್ಲಿ ಏನೋ ಪಂಚಾಯತಿ ಆಗ್ತದದು
9% interest.
ಅದು ಕಡಿಮೆ ಮಾಡಿದ್ರು
6% ತಗೊಂಡ್ರೆ ಎಷ್ಟು ಬರುತ್ತೆ? 7 ವರ್ಷ ಅಂದ್ರೆ
42%. 7 ಅಂದ್ರೆ 8 ಲಕ್ಷ, ಸುಮಾರು ಒಂದು
11 lakhs is the amount due. What is it you can realistically offer immediately for them to accept? Because I won't be able to dispose it off because they are served and unrepresented. It can't be a settlement. If you are going to offer some sizable sum, I'll ask Shastri to consult them and agree, or else I'll dismiss the appeal. Thursday Shastri. Wednesday.
ನನ್ನ ಸಜೆಷನ್ ಕಡಿಮೆ ಮಾಡೋ ಕೊಟ್ಬಿಟ್ರೆ ಏನೋ ಇನ್ಶೂರೆನ್ಸ್ ಇಲ್ಲ, ಏನೋ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರುತ್ತೆ,
ಅದಕ್ಕೆ ನಾನು 11 ಲಕ್ಷ ಆಗುತ್ತೆ.
ದಟ್ ಈಸ್ ಬೆಟರ್. ನನಗೇನ
ರೀಸನಬಲ್ ಅಂದ್ರೆ
ಗೊತ್ತಿಲ್ಲ, ಕೇಳಿ ನನಗೆ, ಯಾಕಂದ್ರೆ ಹಾಸನದವರು ಕೇಳಬೇಕು.
Wednesday.
ಹಾಸನ.
ಯಾರು R2 ಯಾರು? They should pretend to take notice for R1. Since R2 was placed ex parte in the trial court, notice to R2 is dismissed. Either take notice for R3, R1, R2. ಹಾಕಿದ್ದೀರಾ? Request is made to dispense with notice to R1 and R2. Said request is granted. Memo ಹಾಕಿ ಈಗಲೇ. ಇದು ಸೇಮ್. Kumar to take notice for R3. Dispense notice to R1 and R2. Dispense with that request. Take notice for R1. Notice to R2 dispense with that request. Fixed time is going to be. R1, R2, R4 ಗೆ dispense it. Notice to R1, R2 and R4 dispense with as request. Memo. As accepted, notice to R2 dispense. Delay of 70 days in filing the appeal is confirmed. Kill our common.
My lord, serial number 23, my lord. My lord, in this, my lord, company told me to accept notice. So next date it will be open.
They will to take notice for R3. R1 and R2. Request is made to dispense with notice to R1 and R2. Said request is accepted and notice to R1 and R2. File a memo, please.
After 2 weeks, my lord.
R1 and Shivana going to take notice for R2 and R3. R1? R1 here. Is requested notice to R1 and R2. Dispensed. Memo.
I am for the appellant, my lord. Could my lord kindly have it on Wednesday? I am on BC.
Wednesday.
Just a day's accommodation I have some. Finally, it could be disposed of Wednesday, my lord.
Wednesday.
Oblige.
Fixed time. On Wednesday. Notice to A1 problem. A1 but be dismissed as not. In amendment, you know. Notice to dispense. Notice to R1 dispense with as requested. CR Ravi Shankar to take notice for respondent. Other respondent. Who's R1? R1 dispense ಮಾಡಕ R1 ಬೇಕಲ್ಲ, R1 ಬೇಕಲ್ಲ. ಇಲ್ಲ ಕ್ಲೇಮೆಂಟ್ ತಾನೆ R1. ಯಾರು ಆಬ್ಸೆಂಟ್ ಆಗಿದ್ರು? ಇಲ್ಲ ಕ್ಲೇಮೆಂಟ್ ಇದ್ರೆ ನಾನು ಹೆಂಗೆ? Without the claimant, how can I dispose it of? Await service of notice on R1. Service of ಬರೋರ್ಗು I can't do anything. Harish Babu. I'll notice someone bunny. And council is also permitted to take out notice. The council of this for first moment. The exhibition proceedings which are stated to adjourn by Sarvanament. ಏನ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ? By oversight, in paragraph 13, it stated that the appeal was dismissed. So, in the body of the judgment, it had been clear that the insurer should not be exonerated and the principle of pay and recovery. The pay and recovery ಬರುತ್ತಾ? Has been stated. Shimana's case, whose case? 13 is modified. And it should read as a result, the appeal is disposed of, directing the insurer pay the compensation. Thereafter, record this. Just to issue corrected copy of the order we have first. We have 1/2022. Year 813 days in settings. और हाकिरोदा समय हाकिरोदा recording. Recall ಆದ್ರೆ ಈಗ recall ಆದ್ರೆ ಅವಾಗ ನೆಕ್ಸ್ಟ್ ಏನಾಗುತ್ತೆ? ಏನದು? ಇಲ್ಲ ಕೃಷ್ಣಮೂರ್ತಿ ಇಲ್ವಾ? ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ಫಸ್ಟ್.
That serial number 29, not.
Yes, ಅದೇ ಪೇ ಅಂಡ್ ರಿಕವರಿ ಮಾಡಿದ್ದೀನಿ.
Now, office may be ordered to give a free copy.
ಹೇಳಿದ್ದೀನಿ. ಕೆಳಗಡೆ ಮ್ಯಾಟ್ರಿಕ್ 7.1 ಅಲ್ಲಿ notice to R2 is dispensed with since it is already, so notice to R1 is dispensed with as requested. Shri Vijay Kumar is there to take notice for R2. Injury or death? Injury or death? Injury or death? Stay on the ground. What is the other ground? What is the tribunal held? Has the tribunal considered it? She was taken to the hospital immediately.
ಅದೇ ಸಮಯ ಅವರು ಒಪ್ಕೊಳ್ಳಲ್ಲ, ಯಾಕಂದ್ರೆ ಟೋಟಲ್ ಇಷ್ಟ ಆಗುತ್ತೆ, ನಾವೇ ಯಾಕೆ ನಿಮ್ಮ ಹತ್ರ ಮಾಡೋದು ಅಂತ ಹೇಳ್ತಾರೆ.
You can take it as a 10%.
Where was she treated for a head injury? Head injury health treatment ತಗೊಂಡಿದ್ರು? Discharge summary ಇದೆಯಾ? How old was she? What was the date of the accident? ಎಷ್ಟು ನೋಡಿದಾರೆ ಅವರು ಡಿಸೇಬಿಲಿಟಿ? Kumar. She has verbal working memory problems. Income ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಯಾವ ವರ್ಷದ್ದು? ಮಧ್ಯಾಹ್ನ ಹಾಕೊಳ್ತೀನಿ, ಓದ್ಕೊಳ್ಳಿ. 2:30. You have 38 days in filling your figures.
I appeal for the respondent, my lord. 32.
ಏನ್ ಮೇಡಮ್ ಇದೆ ಮಿಸ್ಟೇಕ್?
Death case idu. Death case of 72 years old person died due to accident, but income has not been established and dependency have not been established. That's why the tribunal has passed rightly passed the award, my lord.
ಹೆಂಡತಿ ಇದಾರಾ?
ಹೆಂಡತಿ ಒಬ್ಬರೇ ಡಿಪೆಂಡೆಂಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಮಕ್ಕಳು 3 ಜನದಲ್ಲಿ ಒಬ್ಬರು ಮಾತ್ರ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ. They are not dependents.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಇನ್ಕಮ್?
6,000 ತಗೊಂಡಿದ್ದಾರೆ.
2000?
6,000 ತಗೊಂಡಿದ್ದಾರೆ. 2018 accident. 72 years old aged person.
What was he doing before he retired?
ಏನು ಏಜೆಂಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅಷ್ಟೇ. ಈಸ್ ಎ ಕೂಲಿ ಆಕ್ಚುಲಿ. Some broker. Whatever the tribunal has considered, it is rightly that has been considered, my lord, because they have not proved it.
Then I'll apply the notional income. KSLSA does not make any distinction regarding the age. Somebody dies 2018 is 12,500.
KSSR rule ತಗೊಂಡ್ರೆ ಪೆನ್ಷನ್ ಅಂತ ತಗೊಂಡ್ರು 12,500 ಅರ್ಧ ತಗೊಳ್ಬಹುದು ಸ್ವಾಮಿ. 12,500 ಇನ್ಕಮ್ ಅಂತ ತಗೊಂಡ್ರೆ ಅದ್ರ 72ನೇ ವರ್ಷದಲ್ಲಿ 12,500 ಯಾರು ತಗೊಳ್ತಾರೆ?
6,000 ರೂಪಾಯಿ ಎಷ್ಟು ತಗೊಂಡ್ರೆ ರಿಡಕ್ಷನ್?
50% ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು, 12,500 50% ತಗೊಳ್ತೀನಿ ಬಿಡಿ.
I leave it to your lordship because my contention is that, my lord, as per the service rule, if you go by service rules, retired persons will get half of the value.
I'll apply the same principle. ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅವರು? In respect of an accident which is not in dispute and the liability of the insurer to satisfy the compensation is also not in dispute, the tribunal has awarded some following sums, page 20. In arriving at the said sum, the tribunal has determined the notional income of the deceased at rupees 6,000. In my view, in regard to the fact that the notional income determined by KSLSA in the case of accident of year 2018, 500 would be appropriate to apply the said notional income of rupees 12,500. As the deceased was aged 72 years and only his wife would have been dependent on him, 50% is deducted towards his personal expenses, and the notional income for the purposes of determining cause of dependency is taken as rupees 6,250. Applying the multiplier of 5,
5.
The claimants will be entitled to some rupees also towards loss of dependency. The claimants being the wife and son, Each of them would also be entitled to a sum of rupees 44,000 each towards cost of the action, and a further sum of rupees 33,000 towards under the convention rates. Consequently, payments will be for instance. Deposit ಏನು ಹೇಳಿದ್ದಾರೆ? Dispersal shall be terms of the award of the tribunal. 50%. Coordinate benches and division benches. And madam,
Dependency, my lord, they have not established the dependency. Neither they have produced that they are depending on the income of the deceased, not even a single document. They have to establish that. All are major children and working children.
Apparently there was a mentally challenged dependent. ಅವ್ರು 72 ವರ್ಷ ಇದ್ದಾಗ ಸಂಬಳ 12,000 ಸ್ವಲ್ಪ if you don't have any evidence to accept ಅಲ್ಲ ಒಪ್ಕೊಳ್ತೀನಿ, ಬಟ್ ಇನ್ಕಮ್ ಏನಿದೆ ಪ್ರೂಫ್? ಅದಕ್ಕೆ ನಾನು 12,000 ತಗೊಂಡು ಅರ್ಧ ಮಾಡಿದೆ. ಅವ್ರು if he was working 12,500, if he is retired, madam, 50% of the salary he will get as pension. Basis ಒಬ್ಬರೇ ಡಿಪೆಂಡೆಂಟ್ ಆಗ್ತಾರೆ. ಎಪ್ಪತ್ತೆರಡು ವರ್ಷ ಅವ್ರ ಮಾತ್ರೆಗಳಿಗೆ ಜಾಸ್ತಿ ಆಗತ್ತೆ ಖರ್ಚು. ಎಷ್ಟು ವಯಸ್ಸಿದೆ? 60 years. ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಮಾಡೋಣ ಬನ್ರಿ, ಬೇಡ. During a death, the Fortuner case. In Margament. Yes. Australia. Who says that? Where does he say that the car toppled? In case ಅಂದ್ರೆ the motorcycle. You are inmate of the Toyota Fortuner. Where has he said that? Is PW? W1 now. He has not said your car has fallen turned turtle. Torsi Torsi. He has not said falling down from the car. I fell down and tantra. He has not said outside the car. Was he treated in any hospital immediately? Was he taken to any hospital immediately? What was the injury suffered by him? What was the injury suffered by him? RTA, this is everything. 321. RTA here, I think. 2.5 billion. 4 million. Suddenly, ask the balance of the vehicle into the divider and at the injury to the suspect. But if we are allowing the record, how we can do the injury to the suspect? The injury to the suspect. That for every goes to the result. CPR, fracture, fracture of metatarsus. Then you are also going to see the Malla one simple letter they have produced. It will be nice. P9, huh? You shifted to Unity Hospital. But as much as the extent of factor of that video, the regular say on the left hand, if you are both the same is really a fracture of tibia, then fracture of tibia should be noted in the heart. So only tibia is how to explain, then the tibia from the tibia, so how then so you given then he gave a statement kind of living what is the point that you're trying to make? What evidence have you adduced to show that he was not traveling? Yes. You want to read the entire thing or you want to read relevant portion? Yes. ಅಮ್ಮನ ಗಾಡಿಯನ್ನು ನಾನು ತೆಗೆದುಕೊಂಡು ನನಗೆ ಕಾಲು ಹೊರಟು ಡ್ರೈವರ್ ಲೈಸೆನ್ಸ್ ನನ್ನ ಡ್ರೈವಿಂಗ್ ದ್ವಿಚಕ್ರ ವಾಹನ ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ ನಾನು ಭಾಗವಹಿಸುತ್ತದೆ ಇದು ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ನಾನು ಭಾಗದಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದೆ ಎಂದು ಪೊಲೀಸರು ಆರೋಪಿಸಿದಾಗ ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ. But no statement was taken. ಅದಕ್ಕೆ ಹೇಳಿಕೆಯನ್ನು ಕಾರಿನಲ್ಲಿ 5 ಜನ ಇದ್ದರು. ಕಾರಿನಲ್ಲಿ ನಾನು ಕಾರಣ ಫ್ರಂಟ್ ರೈಟ್ ಸೈಡ್ ಬೇರೆಯವರ ನನ್ನ ಗೊತ್ತಾಗಿತ್ತು. ನಾನು ಗಾಡಿ ಓಡಿಸುತ್ತಿಲ್ಲ, ಸತೀಶ್ ಶೆಟ್ಟಿ ಗಾಡಿ ಓಡಿಸುತ್ತಿದ್ದರು. ನಾನು ಕಾರನ್ನು ಓಡಿಸುತ್ತಿದ್ದೆ, ರೈಟ್ ಸೈಡ್ ಇದ್ದ ಕಾರಣ ನನಗೆ ಏಟಾಗಿತ್ತು. ಅಪಘಾತ ನಂತರ ಪುತ್ತೂರಿನ ಮಂಗಳ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗುತ್ತಿದ್ದೆ. hero variable that it is not so conscious of the way he was but the certificate produced the Mangala family. Each day, Avadu Nanda, Purna Mangala hospital. Do you have any eyewitness to indicate that he was not in the car? The best. The fact remains that you have no positive evidence indicating that he was not a passenger in the car. Correct. Your inferences from this. See, all this argument would hold good if you have some evidence. You are just arguing. I don't know. You tell me. You are the engineer. So according to you, he faked this fracture on the same day of the accident and for the purpose of claiming compensation. Now that is the argument. Fracture agilla antana. The fraud anta heladalla Vijaykumar, you have to establish that, you have to plead and prove fraud. He has borrowed his brother's car. Does not mean that he was driving the car. ನೀವು ಯಾವ ತರ ಕ್ವೆಶ್ಚನ್ ಕೇಳ್ತಾರ ಆ ತರ ಆನ್ಸರ್ ಮಾಡಿದ್ದಾರೆ. ನೀವು ಈ ತರ ಆ ಆನ್ಸರ್ ಇಂದ ಈ ಇನ್ಫರೆನ್ಸ್ ಅಂತ ಬಂದ್ರೆ ಯು ಆರ್ ನಾಟ್ ಅಲಿಜಿಂಗ್ ಎನಿಥಿಂಗ್ ಇನ್ ಯುವರ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇನ್ ಯುವರ್ ಡಿಫೆನ್ಸ್ ಅಂಡ್ ಆನ್ ದ ಬೇಸ್ ಆಫ್ ದಿಸ್ ಯು ಶುಡ್ ನಾಟ್ ಆಸ್ಕ್ ಮೀ ಕ್ವೆಶ್ಚನ್ಸ್. ಯು ಶುಡ್ ಸೇ ದಿಸ್ ಇಂಡಿಕೇಟ್ಸ್. ನನಗೆ ಟ್ರಬಲ್. ದಿಸ್ ಮೈ ಜಾಬ್. ಐ ಜಸ್ಟ್ ವಾಂಟ್ ಯು. Then I go to the next point. The holistic part cannot be estimated. Yes. People do not take clarity and generosity and the name of social rehabilitation. They should not pay it. Here there are in the text, in the degree home, but there is no clear picture about how the accident has taken place and according to this the how went and crash against the road area. Nothing is available in the either in the text or so what can be done to the medical bill is the negative B. Unity 1,02,450. P14. Seal ಇದೆಯಲ್ಲ? Yes. You could have summoned the hospital records and found out whether they were reimbursed by the insurance company. I'm not here to give you a chance to repair your loopholes. ನಾನು ತುಂಬಾ ಕಮ್ಮಿ ರಿಮೈಂಡ್ ಮಾಡಿದ್ದೀನಿ. Maybe one something. Then ಇನ್ನೇನು next ಇನ್ನೇನು? Then ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಏನಾರು ಹಾಕಿದಾರ? What is the income shown in the income tax returns? When was it paid? Accident ಆಗಿದೆ ಯಾವಾಗ? Gross total income is 5,42,000. What is the source of income? Subsequent to that, what is it? According to he is working as a manager in one company in this problem. And subsequently, he says he has been removed from the service. Why is he removed from the service and whether he has been to show that he has been removed? And what about the earlier payment? What are the salary given for him? Is there any intervention model? And that's what 10% disability will not okay, the company can remove you from the service. All the things are there, but I am taking for possession. That is totally false. ಯಾರು ಡಾಕ್ಟರ್ ಯಾರು? ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಓದಿ. ನೀವು ಎಲ್ಲ ಓದ್ತೀನಿ ಅಂತಂದ್ರೆ ನೀವು ಹಂಗಾರೆ ನೀವು ರೆಡಿ ಆಗಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ. ಎಲ್ಲ ಓದ್ಬೇಕು ಅಂದ್ರೆ ಜೊತೆಲಿ ಓದೋಣ ಅಂತ ಅರ್ಥ. ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಪಾಯಿಂಟ್ ಬಂದ್ರೆ ನಾನು ಅಷ್ಟು ಕೇಳ್ತಿದ್ದೆ. ನೀವು ಇಲ್ಲಿ ನನ್ನ ಜೊತೆ ಕೂತ್ಕೊಂಡು ಓದ್ತೀನಿ ಇವಾಗ ಪಾಯಿಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತಂದ್ರೆ ನೀವ್ ಏನ್ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ರೆ ಅದನ್ನ ಹೇಳಿ, ಅದನ್ನ ನಾನು ಕೇಳ್ತೀನಿ. ಇಲ್ಲ ಎಲ್ಲ ಓದೋಣ, ಓದ್ತಾ ಯೋಚನೆ ಮಾಡ್ಕೊಂಡು ಪಾಯಿಂಟ್ ಹೇಳ್ತೀನಿ ಅನ್ನೋದು I adjourned this matter how many days for you to read. ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ತಿರ್ಗಾ ಅವಕಾಶ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸಾಕ್ ಬಿಡಿ. ಹಂಗ್ರಿ ಇವತ್ತು ಸಾಕು. ನಿಮಿಷ ಅವ್ರು ಓದ್ಬಿಡ್ಲಿ. ಓದಿ. ಯಾರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್? ಎಲ್ಲಾರ್ದು ಓದ್ತೀರಾ? ಬರೀ ಯಾರ್ದು? ಕ್ಲೇಮೆಂಟ್. ಸಾಮಾನ್ಯ ಸ್ವರೂಪದ ಸಾಧನೆಗಳಾಗಿ ಗಾಯಗಳು ಗುಣಮುಖವಾದ ನಂತರ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡುತ್ತಾರೆ ಅಂತ ಸರಿ. ನಂತರ ಯಾವುದೇ ಆಸ್ಪತ್ರೆ ಸರಿ ಅದರಲ್ಲಿ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಲು ಯಾವ ರೋಗಿಗೆ ಜೆರಾಕ್ಸ್ ಸಿಗಾಕೊಂಡಿರುತ್ತಾರೆ. ಒರಿಜಿನಲ್ ನಮ್ಮ ಬಳಿ ಸಾಗಿಸು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ನೀಡಿದಾಗ ಒರಿಜಿನಲ್ ದಾಖಲಾತಿ ಬಿಸಾಗಿದೆ ಎಂದು ಯಾವುದೇ ನೆರವಿಲ್ಲ. ರೋಗಿಗೆ ಆದರೆ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಉಪಯೋಗ ಅಮೌಂಟ್ ಕಟ್ಟಿದ ರಸೀದಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನಾನು ಯಾವುದೇ ಮೆಡಿಕಲ್ ನಾನು ಮೆಡಿಕಲ್ ಬಿಲ್ಗಳನ್ನು ಬೇರೆ ಕಡೆ ಟ್ರೈ ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ. ಆಗ ಒರಿಜಿನಲ್ ನನಗಿರುವ ಮಾಹಿತಿ ಮಾತನಾಡುತ್ತೇನೆ. ಆದರೆ ನಾನು ಆಗಿರುವುದಿಲ್ಲ. ಈಗ ನಾನು ಏನು ಕೆಲಸ ಮಾಡುತ್ತಿಲ್ಲ. ಅಲ್ಲಿ ಸೇರಿದ ಬಗ್ಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ತಿಂಗಳು ಸ್ಯಾಲರಿ ಕೊಟ್ಟದಲ್ಲಿ ಸ್ಯಾಲರಿ ಕ್ಯಾಶ್ ಕೊಟ್ಟದಲ್ಲಿ ಕೊಡಬೇಕು. 2019-20 ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಸ್ಟಾರ್ಟ್ ಆಗಿ ಆರ್ಡರ್ ಮಾಡಿದ್ರು. ನನಗೆ ತಿಂಗಳಿಗೆ 60,000 ನಾನು ಯಾವುದೇ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೆ. ನನ್ನ ಮಗಳು ನಾನು ಈಗಲೂ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಯಾವ ರೀತಿ ಇದ್ದೇನೆ ಅದೇ ರೀತಿ ಇದ್ದೇನೆ. ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆ ಪತ್ರದಲ್ಲಿ ಪ್ರಾರ 15 ಹೇಳಿರುವ ಅಂಶಗಳು ಕಾರನ್ನು ನಾನೇ ಓಡಿಸಿಕೊಂಡು ಹೋಗಿ ಅಪಘಾತ ಮಾಡುತ್ತೇನೆ, ನಾನೇ ಓಡಿಸಿದ್ದೇನೆ ಎಂದು ಹೇಳಿದರೆ ಪ್ರತಿ ಓಡಿಸಿದ್ದೇನೆ ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ. ಆ ಕಾರಣ ಕಂಪ್ಲೇಂಟ್ ಇದಕ್ಕೆ ಅಸೆಸ್ ಮಾಡುವ ಮುಂಚೆ ಅಷ್ಟೇದಾದ್ರು ಏನು ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದಾನೆ ಆಗ ಅರ್ಜಿದಾರ ಫ್ರಾಕ್ಚರ್ ಯುನೈಟ್ ಆಗಿದೆ ಎಂದರೆ ಸರಿ. ಅರ್ಜಿದಾರರಿಗೆ 45 ವರ್ಷಗಳಾಗಿಲ್ಲ, ಅವರು ಹಿರಿಯಾಗಿದ್ದ ಫ್ರಾಕ್ಚರ್ ಸರಿಯಿಲ್ಲ, ಸರಿ ಫ್ರಾಕ್ಚರ್ ಅವರ ಯಾವುದೇ ತೊಂದರೆ ಯಾವುದೇ ಮೊದಲು ಗಾಯಗಳನ್ನು ವ್ಯಕ್ತಿಗಳನ್ನು ತಿಳಿದುಕೊಳ್ಳಲು ಅವಶ್ಯಕತೆ ಕಾಲಕ್ರಮೇಣ ಯೂನಿಟಿ ಪ್ರಮಾಣ ಕಡಿಮೆ ಆಗುವ ಸಾಧ್ಯತೆ ಇತ್ತು. ಚಿಕಿತ್ಸೆ ನೀಡಿದ ಒಂದು Is there any reduction in the you are for working also we have not. Now really because one document there is a income tax that also income. There is no mention that how we work. Therefore, the tribunal has taken the account short and the document reduces the fee. Well, it cannot be a base for future of maybe a group of income, but not. But the source of income is not. Therefore, we are avoiding the conflict. So, future loss of income to be 6,05,808. A factor of one is below. Sure, Mohita. Yes. Income is taken as 40,000. Income is taken as 40,000. Sari ಇದೆ ಅಲ್ವಾ ಅದು? Conveyance ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? MFA 1034 or 22 is filed by the insurer challenging the award of the tribunal by which a sum of rupees 8,60,728 was awarded to the claimant for the injuries sustained by him in an accident. MFA 682/2022 is by the claimant seeking for enhancement. It is the contention of the insurer that the occurrence of the accident itself was in serious doubt. It is contended that admittedly the claimant was an inmate in a Toyota Fortuner and it would be next to impossible for the claimant to have suffered an injury as an inmate when the collision was between the Fortuner and the two-wheeler. It is strenuously contended by Sri Vijay Kumar that having regard to the possession of the claimant in the vehicle, the injuries as suffered by him could not be believed. He also submitted that immediately after the accident, the claimant contended that he was taken to an hospital at Puttur and thereafter shifted to Bangalore. Learned Counsel questioned the wisdom of the claimant in shifting himself from Puttur to Bangalore, and according to him, this shifting to an hospital at Bangalore itself was proof that no accident had occurred. He based this submission on the contention that the claimant was a resident at Bangalore, or a resident of Bangalore, and therefore there was no need to shift him to Bangalore. As far as the income determined by the tribunal, it was contended by him that the income tax returns, the acknowledgement for having filed income tax returns, did not indicate the source of income, and there was no other evidence to establish that the claimant was actually earning a sum of rupees 60,000. He also highlighted the fact that the rider of the motorcycle in his complaint had not indicated that the claimant was traveling in the Fortuner and had suffered injuries. And therefore, the entire assertion of the claimant that he had met with an accident while he was an inmate of the Toyota Fortuner car cannot be believed. Ashtal one contention, no? They're not counsel for the claimant on the other hand contended that the determination of income at 40,000 per month was on the lower side. He submitted that the income tax returns had been filed a year prior to the accident, and that by itself indicated that the claimant was earning a sum of rupees 5,72,000, gross income of 5,72,000, and therefore the determination of 40,000 was on the lower side. He also submitted that the assessment of disability at 8%, when the doctor had opined disability at 12%, was improper. Lastly, contended that the amounts awarded towards pain and suffering, food, nourishment, conveyance, and the determination of later periods and loss of future amenities were extremely low. The medical evidence on record indicates that the claimant was initially treated at Mangala Hospital, and Exhibit P9 of the Exhibit 9 P9, which is issued by Mangala Hospital, indicates that the claimant had suffered a fracture in the left fibula and the left metacarpal. It is also recorded that as per the claimant's wish, he was being shifted to Unity Hospital in Bangalore. Exhibit P10, the discharge summary issued by Unity Lifeline Hospital, indicates that the claimant was admitted on 27/1/2019 with a history of road traffic accident. And the final diagnosis mentioned in the discharge summary is that he had suffered a fracture of the distal tibia and fibula of the left ankle, apart from a fracture to the fifth metacarpal base left hand. And he had also suffered facial injury with fracture of the medial wall of the right orbit. The discharge summary indicates that he was hospitalized from 28/1/2019 till 2/2/2019, during which he underwent a surgical procedure on 29th of January. In my view, these medical records clearly establish without any doubt that the claimant did suffer an injury on the 27th and was immediately taken to an hospital and treated. The medical records clearly indicate that he went to the hospital with a history of a road traffic accident. In my view, these medical records by themselves are sufficient proof to come to the conclusion that there was an accident between the two-wheeler and the Toyota Fortuner, and that more importantly that the claimant was an inmate of the car. The argument of the insurer to the contrary is therefore rejected. As far as compensation is concerned, the tribunal, after determining the income of the claimant at 40,000 per month and assessing disability at 8%, has awarded the following sums. As narrated above, the claimant suffered 3 fractures. And in order to assess their disability, Dr. Nagaraj, VN, an orthopedic surgeon, was examined. He has stated that the claimant has suffered a physical disability of 37% to the left lower limb and a whole body disability of 12%. Though this doctor is not the treated doctor, in my view, his assessment of disability at 12% cannot be disregarded, as it is in consonance with the injuries suffered by the claimant. The disability is therefore assessed at 12% as against 8%. As regards the income of the claimant is concerned, the tribunal, on assessment of the income tax returns and other documents, has come to the conclusion that the claimant was earning a sum of rupees 40,000. As stated above, the income tax returns indicated that the claimant had declared a return of 5,72,000. The claimant also produced the fee receipts in respect of his 2 children, which indicate that he was paying a school fee of rupees 36,374 and 16,100 bracketally for 1 term. These receipts also indicate the financial capability of the claimant to spend nearly 5,000 to 6,000 rupees a month towards his children's education. In my view, therefore, it would be appropriate to determine the monthly income of the claimant at rupees 50,000 as against the sum of rupees 40,000. The tribunal, since the disability is determined at 10%, the claimant will be entitled to a sum of rupees 50,000 into 12 into 14 to 12% towards loss of future earning. The tribunal has awarded a sum of rupees 1,02,450 towards medical expenses, and this award being based on documentary evidence is affirmed. The tribunal has awarded a sum of rupees 12,400 towards food nourishment, attendant charges, and conveyance charges. The evidence on record indicates that the claimant was shifted from Bangalore to Bangalore and was hospitalized for about 4 days, 4 or 5, 5 days, and therefore it would be appropriate to award a sum of rupees 25,000 towards food nourishment, attendant charges, and conveyance. The tribunal has taken the later period as 2 months. 2 months. In my view, having regard to the fracture suffered by the claimant, it would be appropriate to determine later period as 3 months and award a sum of rupees 1,50,000. The tribunal has awarded a sum of rupees 10,000 towards loss of future amenities. Since the claimant has suffered 12% disability to his whole body, it would be appropriate to award a sum of rupees 75,000 towards loss of future amenities. The tribunal has awarded a sum of rupees 50,000 towards pain and suffering. In my view, having regard to the nature of injury suffered by him, it would be appropriate to enhance the said sum to rupees 75,000. Consequently, the claimant will be entitled to the following sums: 6%, 8 weeks. Appeal of the insurer is dismissed. Appeal of the claimant is allowed in part. Martha. 34, 35, 37, 38, 39, 40, 41, 42, 43, 44, 45, will stay in the number. Notice. Or for records, so to take notice for the insurer. Stay the RD there. Number 36. 36. 50%. Stay ಬೇಡ ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ. Stay ಬೇಕು ಅಂದ್ರೆ 50%. 50% of the award amount you have to deposit. ಎಲ್ಲರಿಗೂ ಕನ್ಸಿಸ್ಟೆಂಟ್ ಬೇಕಷ್ಟೇ ಇಲ್ಲ ನೋಟಿಸ್ ತಗೊಂಡ್ ಬರ್ತೀರಾ ಇನ್ ಚಾಯ್ಸ್ ಇಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿ ಅವ್ರು ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ ಐ ಗ್ರಾಂಟ್ ಯು ಅಷ್ಟೇ issue notice or for records. Council is permitted to take out notice on the claimants to their council in the execution proceedings which are stated as in file. There should be an interim stay of the award subject to the appellant depositing 50% of the award amount before this court in a period of 4 weeks. $47. We are owner ಯಾರು the 47 stay ಯಾಕೆ ಹೇಳ್ತೀರಾ 47 ಅದು ನೋಟಿಸ್ ಆಗಿದೆ 37 notice to R1 ಯಾರು notice to
47 my lord I am appealing for the appellant.
notice to ಯಾರಿಗೆ ಅವರು ಹೇಳ್ತಾರೆ ಹೆಸರು ಹೇಳ್ತಾರೆ ಯಾರು ಅವ್ರು number 47
my lord, after the insurance company my lord challenging the my lord award passed by the tribunal on quantum my lord the respondents number 1 to 3 my lord they are the majors my lord father and mother father and two sons my lord were aged about 29 and 26 my lord the tribunal has awarded my lord a loss of dependency they awarded my lord. They are entitled only for the loss of estate 50% but the tribunal has awarded my lord loss of dependency.
Madam, death of a female.
Death of a female, yes.
ಯಜಮಾನ್ರು ಇದ್ರಲ್ಲ
ಅಲ್ಲ ಮಕ್ಕಳಿಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ ಲಾಸ್ ಆಫ್ ಡಿಪೆಂಡೆನ್ಸಿ ಮಕ್ಕಳು
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ
ಇನ್ಕಮ್ ಮೈ ಲಾರ್ಡ್ 12,000 ಮೈ ಲಾರ್ಡ್ ಅದೇ 12,500 12,500 ಮೈ ಲಾರ್ಡ್ ಆಕ್ಚುಲಿ 2018
ಸರಿ ಇದೆಯಲ್ಲ ಹಂಗಾರೆ ಇನ್ಕಮ್
ಅಲ್ಲ
ರಿಡಕ್ಷನ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ
2019 ಲಾಸ್ ಆಫ್ ಡಿಪೆಂಡೆನ್ಸಿ ಇದು ಮಾತ್ರ
ರಿಡಕ್ಷನ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ
ಒಂದು ಥರ್ಡ್ ತಗೊಂಡಿದ್ದಾರೆ
ಸರಿ ಇದೆಯಲ್ಲ ಹಂಗಾರೆ
ಅಲ್ಲ ಒಂದು ಥರ್ಡ್ ಲಾಸ್ ಆಫ್ ಡಿಪೆಂಡೆನ್ಸಿ ಕೊಡೋದೇ ತಪ್ಪು ಅಂತ ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ ಯಾಕಂದ್ರೆ ಲಾಸ್ ಆಫ್ ಎಸ್ಟೇಟ್ ಅಲ್ಲಿ ಬಿಕಾಸ್ ಬೋತ್ ಆಫ್ ದೇಮ್ ಇಲ್ಲ ಅಂದ್ರೆ ಒಬ್ರು ಡಿಪೆಂಡೆಂಟ್ ಆದ್ರೆ 50% ಆದ್ರೂ ತಗೋಬೇಕಾಗಿತ್ತು
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್
ದಟ್ಸ್ ಆಲ್ ಮಚ್
The insurer is appeal challenging the award of rupees 18,77,500 granted to the husband of the deceased and the two children of the deceased who are aged 26 and 23 years. The main contention advanced by the insurer is that the tribunal could not have considered that the claimants were dependent on the deceased and therefore the entire sums awarded towards loss of dependency was incorrect. Next. The deceased was the wife of the first claimant. It was contended that the deceased was returning from her house after attending coolie work at a coffee estate. This assertion by itself is that the claimant, the deceased, was earning and was thereby consequentially contributing to the income of the family. It is to be noticed here that the claimants 2 and 3, our children were aged just 26 and 23 years old. In my view, therefore, the reasoning of the tribunal that they were dependent on her and that she was contributing to the family cannot be found faulty. So I find no reason to entertain this appeal and the same is accordingly dismissed. This shall not, however, preclude the claimants from preferring an appeal if they choose to do so. Pradeep, Notice for records. This is an interesting subject to the entire amount of the person. 58. Notice of
Number 61. CA Mr. Swami.
Notice. And counsel for the petitioner is also permitted to take out notice from Mr. Ravindranath, who appeared in the appeal. In case. Whom do you appear for? You have not paid any appeal. On what ground has you filed an appeal? False implication. Case of injury or death? Policy another package policy na act policy. Record ಬಂದಿದ್ದೀರಾ? DVR Siddharamaya. DVR ಗೆ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಏನೋ submitted to Kasturba Hospital. ಇವೇನು ಅಪೀಲ್ ಹಾಕಿಲ್ವಾ? ಯಾವ್ದು ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಅವ್ರು ಯಾವ್ದು ಹೇಳಿದ್ದು? ಫೀವರ್, ಹಿಸ್ಟ್ರಿ ಆಫ್ ಫೀವರ್ R5. ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಾ? PW 1 year. Wife. Doctor, ಯಾರು ಎಕ್ಸಾಮ್ ಮಾಡ್ಲಿಲ್ವಾ? RW1 ಯಾರು? RW1 is near Dr. Mahabadesh. They were shifted to Manipal Hospital. Huh? You know? What has been suppressed? The insurer is an appeal. As in the award of rupees 6,02,000. And to the trade, compensation to the wife, children, wife, daughter, and parents of Ravi alias Raviraj, who was stated to have passed away pursuant to a road accident on 9/9/2009. It is the case of the insurer that the records at Magyan Hospital indicate Raviraj was admitted with a history of fever. Yes, loss of consciousness since 4 a.m. and there was no history of trauma, fall or injury, assault. And therefore, it could not be said that the deceased was killed in a road traffic accident. It is also contended that this information was stated to have been given by the father of the deceased himself. And therefore, this also established that there was no motor vehicle accident. Exhibit R2, which was relied upon, notices records the following. As could be seen from this particular record, the deceased was not conscious and was not therefore responding to questions. Exhibit R1, a summary sheet of the McCann Hospital is also produced, in which it is stated that the deceased was admitted on 10th of September 2009 and was also referred to a higher center on the same day. The provisional diagnosis and final diagnosis read as follows. It is also to be noticed that the discharge summary also indicates that he was unconscious. The claimants produced the post-mortem report, which was dated 15th of September 2009. In the said post-mortem report, the doctors have recorded that as per the information furnished by the police, the deceased was traveling on a bike of his friend and sustained injuries when the bike fell due to the rash and negligent driving of Veerabhadra on 9/9/2009. It is also stated there that the deceased was admitted to Kasturba Hospital on 10/9/2009 and ultimately succumbed to injuries on 15th of September 2009. The postmortem report records the following external injuries to the deceased. And the internal examination has been recorded as follows. The ultimate opinion as to the cause of death is stated to be head injury, secondary to blunt force trauma to the head. In my view, having regard to the fact that the body of the deceased had a surgically made sutured wound over the front of his head and other injuries to his head clearly indicate that he had suffered an accident. The injuries recorded clearly are in consonance with the road traffic accident. It is to be kept in mind that the police, after investigation, have laid a charge sheet. Charge sheet against the driver of the two-wheeler, and this also points to the fact that Ravi alias Raviraj suffered the injuries as a result of the motor vehicle accident. The argument of the insurer that because the McGinn Hospital records indicate that he was admitted with history of fever, no accident could be attributed, cannot be accepted in the light of the postmortem report, which clearly records several injuries that the claimant had suffered. And therefore, of the view that there is no merit in the appeal and the same is liable to be dismissed. It is also to be stated here that the motor vehicle in question was issued with a package policy. Therefore, the liability of the insurer to pay compensation to the pillion rider cannot be denied. The result, the appeal is dismissed. Sitaram Rao. Sitaram Rao. Anup.
Cell number 63.
So, 2014 cross objection. Frivolous appeal, frivolous cross objection. In case of injury, na? Treated doctor ಇಲ್ಲ ಇಲ್ಲ ಅವರು ಒಂದು ರೆಪ್ಯುಟೇಷನ್ ಬಂದ್ಬಿಟ್ಟಿದೆ ಇವ್ರು ಬಂದು ವಿಟ್ನೆಸ್ ಕೊಡೋದು ಡಿಸ್ಚಾರ್ಜ್ ಸಂಬಂಧ ಏನಾರು ಇದೆಯಾ ಏನ್ ಇಂಜುರೀಸ್ in 6 and 7 income ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ 5,000 ಎವಿಡೆನ್ಸ್ ಅದೇ ಕ್ವೆಶ್ಚನ್ ತಿರ್ಗಾ ಪ್ರತಿ ಸಲನು ನಾವಿಕಲ್ಲ %10 ಸರಿ ಇದೆ ಏನಿದೆಯೋ ಸರಿ ಇದೆ ಇದ್ರಲ್ಲಿ ಏನೋ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಡಿಸಾಸ್ಟರ್ ಸಮರಿಂದ ದಟ್ ಹಿ ಸಫರ್ಡ್ ಫ್ರಮ್ ಎನಿ ಸೀರಿಯಸ್ ಪ್ರಾಬ್ಲಮ್ ಇನ್ಕಮ್ ಒಂದು ಜಾಸ್ತಿ ಮಾಡ್ತೀನಿ ಮಿಕ್ಕಿದೇನಾ ಅದೆಲ್ಲ ಕೊಡ್ತೀನಿ I'll increase the pain and suffering and loss of amenities. Then, chalwa. So how does it make a difference? Like, did you produce any evidence to show that because he was drunk, came onto the road and the accident occurred? Correct. How can you say that merely because he's drunk alcohol, he caused the accident? What is there to show that he caused the accident or contributed to the accident in any way? ಅದು ಹಿಂದೆಯಿಂದ ಬಂದು ನೋಡಿದಿರೋದು. MFA 8410 of 2012 is filed with the claimant seeking for enhancement. What I should tell you, K. Shanta takes notice to the cross objection is also preferred by the insurer, contending that there was evidence on record to indicate that the claimant was a pedestrian, had consumed alcohol, and therefore some degree of contributory negligence ought to have been attributed to the pedestrian. There is absolutely no evidence adduced by the insurer indicating that the claimant in a drunken state had come onto the road and invited the accident to himself. Merely because the pedestrian had consumed alcohol, that would not lead to the inference that he had contributed to the accident. Therefore, of the view that there is no merit in the cross objection, the same is accordingly dismissed. As far as compensation is concerned, the tribunal has taken the income of the claimant mostly at rupees 3,000 per month, assessed disability at 8%, and awarded the following sums. The claimant is thus in appeal, seeking for enhancement. As far as disability is concerned, in my view, the determination of disability at 8% by the tribunal cannot be found faulted. However, as regards income, since KSLSA has determined the income for accidents of year 2009 at rupees 5,000 to be appropriate to apply the said income to this case, and consequently the claimant will be entitled to sum of rupees 5,000 into 12 into 14 into 8% towards loss of future earnings. The claimant had suffered fracture to the clavicle and was hospitalized for 21 days. The discharge summary indicates that he had also suffered multiple rib fractures and he had also developed sudden onset of chest pain and was shifted to MICU. This view of the matter, it would be appropriate to enhance the award of rupees 25,000 to rupees, enhance the award from rupees 25,000 to rupees 50,000 towards pain and suffering. The tribunal has awarded a sum of rupees 15,000 towards loss of amenities and happiness. In my view, since the claimant has suffered 8% disability, it would be appropriate to enhance the said sum to rupees 30,000. The sum of rupees 1,43,000 awarded towards medical and incidental charges. ಎಷ್ಟು medical bill exact? Required to be enhanced. So since the medical expenses was rupees, correct amount idea by le 1,40,250. Itself was rupees 1,40,000, and the claimant was hospitalized on 2 occasions for about 21 days. In my view, therefore, it would be appropriate to award some rupees 1,41,000 towards medical expenses and some more rupees 25,000 towards food nourishment, conveyance, and attendance charges. The tribunal has determined the later period as 3 months. Since the claimant was admitted twice, it will be appropriate to determine the later period as 5 months and award a sum of rupees 25,000 towards loss of income in the later period. Consequently, the claimant will enter the following sums. Yes, of ಆರ್ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ. ಜೀಪ್ಗೆ ಇನ್ಶೂರೆನ್ಸ್ ಇರ್ಲಿಲ್ವಾ? ಇಲ್ಲ, ಜೀಪ್ಗೆ ಇನ್ಶೂರೆನ್ಸ್ ಇರ್ಲಿಲ್ವಾ? ಅವ್ರ ಅಪಿಯರ್ KSRTC ಸಿಗ್ತಾನೆ. ನಿಮ್ ಗಾಡಿಗೆ ಇನ್ಶೂರೆನ್ಸ್ ಇರ್ಲಿಲ್ಲ ಹಂಗಾರೆ? ಚಾರ್ಜ್ ಶೀಟ್ ಅವನ ಮೇಲೆ ಹಾಕಿದ್ರ ಡ್ರೈವರ್ ಜೀಪ್? ಇಲ್ವಾ? ನಿಮ್ದು ಇನ್ಶೂರೆನ್ಸ್ ಇಲ್ವಾ? ಕರ್ಬಲ್ ನೀವು ರಾಂಗ್ ಸೈಡ್ ಬಂದು ಹೊಡ್ತಿದ್ದೀರಾ ಬಸ್ಗೆ. Yes. ಇದು ತಪ್ಪೇನಿದೆ? ಇಲ್ಲ ನಿಮ್ಗೆ ಎನ್ಹಾನ್ಸ್ ಮಾಡಿದ್ರೆ ಏನ್ ಸುಖ? ಅವ್ರ ಮೇಲೆ ಹೋದ್ರೆ ಅವ್ರ ಕಾಸು ಸಿಗುತ್ತೆ ನಿಮ್ಗೆ. ಡ್ರೈವರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರ ಅವರು? ನೀವು ಇನ್ಮೇಟ್ ನೀವು? You are an inmate in. How many people died? 2, 3. ಅವ್ರೇನ್ ಕೇಸ್ ಹಾಕ್ಲಿಲ್ವಾ ಜೀಪ್ ಡ್ರೈವರ್? ಒನ್ 163 ಏನೋ 166. ಇನ್ಶೂರೆನ್ಸ್ ಇಲ್ಲಲ್ವಾ ನಿಮ್ ಜೀಪ್ಗೆ? ಅಟ್ ಬೆಸ್ಟ್ 10% ನೆಗ್ಲಿಜೆನ್ಸ್ ಅಷ್ಟೇ ಬಸ್ ಮೇಲೆ. 1 ಲಕ್ಷ ರೂಪಾಯಿ ಹತ್ರ ಬರುತ್ತೆ ಅಷ್ಟೇ. ಮಿಕ್ಕಿದ್ಯಾರ ಕೇಸ್ ಇದ್ರೆ ಏನು ಅದು ತೊಂದರೆ ಆಗುತ್ತೆ. ಬೇರೆ ಕೇಸ್ ವಜಾ ಹೋಗಿದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? ನಂದೊಂದು ಜಜ್ಮೆಂಟ್, ಇನ್ನೊಂದು ಜಜ್ಮೆಂಟ್. No, suppose in some other case 2:30 ಬನ್ನಿ, ಅವ್ರ ಅಂಗಡಿಯವ್ರು ಬರ್ತಾರ ನೋಡೋಣ. Drivers? ಏನಂದ್ರೆ ರಿಜಿಡ್ ಚಾಸಿ. ಬರುತ್ತಂತ ಹೇಳಿ. ರೆಕಾರ್ಡ್ ಆಗ್ತಾ ಇದೆ ಸರ್. ಆಕ್ಸಿಡೆಂಟ್ ಯಾವಾಗ ಆಗಿದ್ದು? ವೆನ್ ವಾಸ್ ದಿ ಆಕ್ಸಿಡೆಂಟ್? 12 10. ಎಲ್ಲಿದೆ ನೀವು ರಿಜಿಡ್ ಚಾಸಿ? First page of valid details. Transport 18/11/2019 to 17/11/2000. Not able to find that here. Accident ಯಾವತ್ತಾಗಿದೆ ಅಂದ್ರೆ So according to 88 was LMV non-transport car. Then transport valence rigid chassis. Are you saying that the vehicle that you did a test drive would be indicated in the license? ನೀವು ಯಾವ ಕ್ಲಾಸ್ಗೆ ನೀವು ಅಪ್ಲೈ ಮಾಡ್ತೀರೋ ಆ ಕ್ಲಾಸ್ ವೆಹಿಕಲ್ ತಗೊಂಡು ಹೋಗ್ಬೇಕು. ನೀವು ತಗೊಂಡು ಹೋಗ್ಬೇಕು, ಅವ್ರು ಕೊಡಲ್ಲ. ನೀವು ತಗೊಂಡು ಹೋಗ್ಬೇಕು, ಆ ಗಾಡಿ ಓಡಿಸಿ ತೋರಿಸ್ಬೇಕು ಅವ್ರಿಗೆ. ನೀವು ಯಾವ್ದೋ ಇಲ್ಲಿ ನೀವು ತಗೊಂಡೋಗಿದ್ದಕ್ಕೆ ಅದು ದಿಸ್ ಇಸ್ ಟೂ ಫಾರ್ ಥಿಯರಿ. But our argument ಇಲ್ಲ. Rigid chassis ಅಂತ ಅಲ್ಲ. So your second argument may be attractive, saying that so long as it's a transport vehicle, whether you drive a rigid chassis or other additional document. ಇಲ್ಲಿ TRB rigid chassis 6991 ಅಂತ ಅಂತಾರೆ ಅಲ್ಲ. If it's rigid chassis is also a transport vehicle ಆದ್ರೆ it's TRV ಅಂತ ಹಾಕಿದ್ದಾರೆ, indicating it's a transport vehicle. So if he has obtained a license to drive a transport vehicle, then how can you say that he does not possess the requisite endorsement to drive a transport vehicle? Like ಏನಾದ್ರೂ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ವೆಹಿಕಲ್ ತಾನೆ ಅದು, ವೆದರ್ ಇಟ್ಸ್ ಕರೆಕ್ಟ್. ಬಟ್ ಅದು ಏನಂತ ಹೇಳ್ತಾರೆ, ಡೆಫಿನೇಷನ್ ಏನು? Includes a chassis to which a body has not been attached. It includes a chassis to which a body has not been attached and a trailer. So it is a motor vehicle. Sorry, if it's a motor vehicle and if it is classified as transport, then ಅದು ಚಾಸಿ ಓಡಿಸೋದಕ್ಕೆ ಒಂದು ಸಪರೇಟ್ ಕ್ಲಾಸ್ ಇರ್ಬೋದು. But so long as it is a transport vehicle, whether it's a rigid chassis vehicle or a heavy goods vehicle. ಅಲ್ಲ ಪ್ರದೀಪ್, ಅವನು ಲಾರಿ ಚಾಸಿ ಓಡಿಸೋ ಸ್ಕಿಲ್ ಒಂದೇ, ಲಾರಿ ಪೂರ್ತಿ ಬಾಡಿ ಬಿಲ್ಡ್ ಮಾಡಿ ಓಡಿಸೋದು ಸ್ಕಿಲ್ ಒಂದೇ. Which is that provision which relates to granting of license for rigid chassis? ಇದರಲ್ಲಿ ಅಲ್ಲ ನಮ್ಮ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಅದು ಮೋಟರ್ ವೆಹಿಕಲ್ ರೂಲ್ಸ್. Because he is right when he says the skill to drive chassis vehicle would be different than the skill to drive goods vehicle which is laden with goods. It will be much more heavier, and therefore a separate license could be needed to drive that. The chassis is only more or less driving like an LMV without the weight of the goods. Now it is no doubt a transport category vehicle, but what he says is correct, saying that when the skill to drive a lorry full of weight as compared to only a chassis vehicle is completely different. Assuming it is still a transport vehicle, you don't have the license to drive heavy goods vehicle. Even in LMV is a goods vehicle, is a transport vehicle. Yes. No, in Mukund Devan's case, you are considering fundamentally whether a light motor vehicle is a transport vehicle having regard to the limits. No, the fundamental principle decided there was because in relation to a light motor vehicle, because that is also a transport vehicle. But they did not say that having LMV, you can also drive a heavy goods vehicle. Then ಹೇಳಿಲ್ಲ ಅವ್ರು ಹೇಳ್ತಿರೋದು transport vehicle includes, yes, a transport vehicle would also include a light motor vehicle, a medium goods vehicle and a heavy goods vehicle. From this does not follow that a license to drive an LMV is also the license required to transport vehicle. Transport vehicle would mean a public service vehicle, a goods carriage, an education institution bus, or a private service vehicle. That is the definition of transport vehicle after the amendment. You are rereading the entire section 10 if this argument is accepted. We are rereading the entire section. If this argument is accepted, once a license is granted to drive a transport vehicle, according to you, you can drive any transport vehicle. Please read the two questions that are framed, 4 questions in Mukund Devan case, para 3. Then, how can you stretch it that far from Mukund Devan case to say transport vehicle license ತಗೊಂಡ್ಬಿಟ್ರೆ ನಿಮ್ಮ argument further extend ಮಾಡ್ರೆ LMV license ಇದ್ರೆ because for the questions over the para 3. Para 3 over the first. We will see the answers with reference to the questions. Maybe that is the correct way of the answer to first question. which you read 50, would have to read in the light of this question. What is the meaning to be given to the definition of light motor vehicle as defined in section 221 of the MV Act? Whether transport vehicles are excluded from it. In that context, they said, even if it's a light motor vehicle, it is a transport vehicle. Nala question ಓದ್ಬಿಡಿ ಅವಾಗ maybe you'll understand the argument better. ನಾಲ್ಕು ಓದ್ಬಿಡಿ. Both of them are interrelated. First one is this: what is the meaning to be given? The definition of light motor vehicle as defined in section 221 of the MV Act. Whether transport vehicles are excluded from it. The answer to it is no. An LMB is also a transport vehicle. That is the answer to the first question. Second one, whether transport vehicle and omnibus, the gross vehicle of either of which does not exceed 7,500 kilos, would be a light motor vehicle. And also motor car or tractor or road roller, unladen weight of which does not exceed 7,500 kilos, load of a license to drive the class of LMB as per section 10(2)(d) would be competent to drive a transport vehicle or omnibus, the gross vehicle weight of which does not exceed 7,500 kilos, or a motor car so and so of the 7,500 kilos. So if you have a driving license to drive an LMB, by automatic implication, you also have the right to drive a transport vehicle, gross vehicle weight of which does not exceed 7,500 kilos. So these are the only two things that I want. Now kindly read question 3. ಎರಡು ಕ್ವೆಶ್ಚನ್ ಓದ್ಬಿಡಿ ಅವಾಗ ಮೇ ಬಿ ಆ ಕ್ವೆಶ್ಚನ್ ಓದಿದ್ರೆ ಆನ್ಸರ್ ಅರ್ಥ ಆಗುತ್ತೆ. ಆನ್ಸರ್ ಮಾತ್ರ ಓದಿದ್ರೆ ವಿದೌಟ್ ರೆಫರೆನ್ಸ್ ಟು ಕ್ವೆಶ್ಚನ್. ಇಲ್ಲ ಭಟ್ರೆ argument it will be pushing Mukundev's case far beyond the questions. Once you say that you obtained a transport vehicle, then you will also have to establish that depending on the weight of the vehicle, are you authorized to drive that vehicle? LMB, if you have an LMB license, even a transport vehicle up to 7,500 kilos you can drive without any further endorsement. That is all. That is all Mukundev's case says. Nothing more. What are the rules relating to grant of license to a transport vehicle? What are the rules? Rule. It's Yes. Wait. Yes. 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 So if you have made the application after 2001, this was the form required. When you made the application, what was the form that was required? So what was, and so therefore it required a specific request to drive an MGV or an HGV. What was the license granted to you prior to this 2001 amendment? For those of them who made the application after 2001, you may be right. But if you have made the application prior to that particular date, we will be gone by what you sought for and what is granted to you then. A subsequent amendment will not give you a higher status or an additional endorsement to the driving license. What is your application for? I don't think it's ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಮಾಡಿ ಈ ಕೇಸಲ್ಲಿ ಬೇಡ ಈಗ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಿಲ್ಲ ಅದನ್ನ ಎಲ್ಲೋ that was issued after 2001. You should have produced prior to that. I would accept it straight away. Prior to this amendment, if you had issued, I have no difficulty. You had proved that you had applied for and were given this particular license to drive an HGV. It is not patently clear. It's not patently clear. That is the reason why there is a struggle. Remind ಮಾಡಲ ಇದು ಮುಂದಕ್ಕೋಸ್ಕರ ಆರ್ಡರ್ ಅಲ್ಲಿ ನಂದು ಆರ್ಡರ್ ಅಲ್ಲಿ As regards liability, the current comes appearing for the owner contents that the driver of the vehicle did possess an endorsement to drive a transport vehicle of rigid chassis, and therefore he did possess the right to drive a transport vehicle. Then it comes for the insurer on the other hand contends that the license obtained to drive a rigid chassis, which is also a transport vehicle, would be different from a license that is required to drive a heavy goods vehicle. It is his contention that under the motor vehicle rules, the categories to which a person is entitled to drive is dependent on the weight of the vehicle and the corresponding tests that he is required to undergo. In this case, Exhibit R4 has been produced indicating that the claimant, that the driver did have the following endorsement: PRV rigid chassis. It is, however, not very clear from the evidence on record as to whether this enabled the driver to drive a transport vehicle which he was actually driving when the accident occurred. For this limited purpose of determining whether the endorsement found in Exhibit R4 would enable the driver to drive a transport vehicle of the kind that he was driving, the matter shall stand remitted to the tribunal. It would be open to the owner, the learned counsel, it would be open for the owner to summon the RTO or produce supporting material to indicate that the endorsement mentioned in Exhibit R4 did enable the driver to drive a heavy goods vehicle which he was driving at the time of the accident. So it is, however, made clear that the insurer shall be liable to pay the compensation to the claimant without awaiting the decision of the tribunal on the point noted above, stated above. If the tribunal were to come to the conclusion that the driver could drive heavy goods vehicle, the insurer would not have the right of recovery. If, however, the tribunal were to come to the conclusion that the endorsement relied upon in Exhibit R4 did not enable the driver to drive a heavy goods vehicle which he was driving at the time of the accident, the insurer would be entitled to recover the compensation that it had paid to the claimants. To this limited extent, the appeal is remanded. ಪ್ರಕಾರ ಇಲ್ಲ ಹೋಗ್ಲಿ, ಒಂದ್ಸಲ ಹೋಗ್ಬನ್ನಿ, ಒಂದ್ಸಲ ವ್ಯಾಜ್ಯ ಮಾಡಂಗೆ ನಾಳೆ ಬೇಡ ಅಂತ. Will be transferred to the driver. ನೀವು ಸೋತ್ರೆ amount and deposits to the claimant. The government shall pass appropriate orders on this amount and deposit after the decision of the point which is remanded. Payment appeal ಆಗಲಿ ಮಾಡಿ ನಾನು ಅದೇ ಪೋರ್ಷನ್ ಉಳ್ಕೊಳ್ಳೋದು, ನಿಮ್ಗೇನು ತೊಂದರೆ ಮಾಡಲಿಲ್ಲ, ಅವರಿಬ್ಬರು ಅಷ್ಟೇ. ರವಿಶಂಕರ್, ರವಿಶಂಕರ್
67
ಏನ್ ಗ್ರೌಂಡ್?
challenging the liability on the ground that he was not an employee. Our coolie anta helidare, it's a tempo that they're traveling. Their petition itself indicate that he was an employee of CMC Malo. So he was a government employee. Their petition, column number 2, And also in para 22, they indicate column number 2, he says that he is a tractor driver at a CMC Malur. So to say that he was a coolie in the goods van is incorrect. In an earlier occasion, this honorable para occupation of the person dead another tractor driver, name and address of the employer, CMC Malur.
Where are you reading?
I am reading the petition. Petition. In the petition itself, they admit that the deceased was a tractor driver at CMC Malur. So he could not have been a coolie in the tempo. And even in the column 22 of the petition, para 3.
Carrying capacity ಎಷ್ಟಿತ್ತು?
Capacity, if it's a goods vehicle, 6 persons ಗೆ ಇದೆ.
ಇವರು ಬರ್ದಿದ್ದಾರೆ ಟ್ರ್ಯಾಕ್ಟರ್ ಡ್ರೈವರ್ ಅಂಡ್ ಕೂಲಿ ಅಂಡರ್ ದಿ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಅದೇ ಹೇಗೆ ಸರ್? ಎಲ್ಲ ಅಲ್ಲ, ಟ್ರ್ಯಾಕ್ಟರ್ ಡ್ರೈವರ್ ಬೇರೆಯವರದಲ್ಲ, ಗವರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯಿ, CMC Malur.
ಅಲ್ಲ, ಅದು ಬರ್ದಿಲ್ಲ, ಇಲ್ಲಿ ಬರೀ ಬರ್ದಿರೋದು.
ಬರ್ದಿದ್ದಾರೆ. ಐ ಆಮ್ ರೀಡಿಂಗ್ ದಿ ಪೆಟಿಷನ್ ಇಟ್ಸ್ column 4.
Column 5.
Column 5, CMC Malur.
How did the accident occur?
It went to, he wanted to overtake. He was not the driver. He was an occupant as a coolie, according to them. And they wanted to overtake a two-wheeler, then hit a roadside curve and fell into the ditch topsy-turvy.
But it was within the permissible carrying capacity of the tempo. What was the carrying capacity of that?
It is within. It is within the permissible. Earlier occasion, this honorable
no matter what they say, you will be liable.
ನಾನು liable ಆಗ್ತೇನೆ. ನಾನು liable ಆಗಲ್ಲ ಸ್ವಾಮಿ. Because carrying capacity ಮೇಲೆ liability ಮಾಡೋದಾದ್ರೆ liable ಆಗ್ತೀನಿ. But by their own statement, he was not an employee of the owner of the goods vehicle. He was an unauthorized occupant. I am not liable.
Where is the RC book?
ಇಲ್ಲ.
RC ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಸರ್, ಬರೀ ಇನ್ಶೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಮಾತ್ರ. ಇನ್ಶೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀವಿ. And the question of the carrying capacity was not the point that is focused. We don't dispute.
Where is the RC? Where is the policy?
R1. ಅಲ್ಲಿ ತಮ್ಮ ತಿಳಿದೇ ಇದ್ರೆ I'll carry this to the seating capacity 3. I'm reading the RC book. Seating capacity is 3. Tata 407. Policy ನಲ್ಲುವೆ 2+1 ಅಂತು, including driver.
ಎಷ್ಟು ಜನ ಇದ್ರು ಗಾಡಿಯಲ್ಲಿ?
He is the
What is mentioned in the FIR as to what was his occupation?
ಅಲ್ಲಿ ಅಪರಾಧ ವರದಿನಲ್ಲಿ ಅಲ್ಲಿ ಹೇಳ ಸ್ಥಳದಲ್ಲಿ ಒಬ್ಬ ಶೇಖರ್ ಎಂಬುವನ ಪ್ರಯುಕ್ತ ಟೆಂಪೋದಲ್ಲಿದ್ದ ಒಬ್ಬ ಶೇಖರ್ ಎಂಬುವನ ತಲೆಗೆ ಮತ್ತು ಎದೆಯ ಮೇಲೆ ರಕ್ತ ಬಂದು ಸ್ಥಳದಲ್ಲಿಯೇ ಮೃತಪಟ್ಟಿರುತ್ತಾನೆ. ಐ ಆಮ್ ರೀಡಿಂಗ್ ಫ್ರಮ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್.
FIR ಅಲ್ಲಿ ಏನಂತ ಹಾಕಿದ್ದಾರೆ?
FIR ಅಲ್ಲಿ village.
Was he actually an employee of the CMC?
He was.
Established.
Their own statement. Nobody established.
Statement irle. Statement is by the lawyer. Is there anything to show that he was an employee of the municipality?
They have not produced. We did not deny that fact. Being
ಅಲ್ಲ, income
respondents, income 3,000 ರೂಪಾಯಿ ಅಂತ ಮಾತ್ರ ತಗೊಂಡಿದ್ದಾರೆ. At an earlier point in time, this was the only subject matter. The court, this honorable court remanded the matter to the trial court to lead. They are not in to indicate that it was not the employer's.
ಪಾಲಿಸಿ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಇಲ್ಲ.
ನಾಳೆ ಹಾಕೋತೀನಿ ದಯವಿಟ್ಟು ಸ್ವಾಮಿ, ನಾಳೆ ತರ್ತೀನಿ. I will bring the policy, FIR, charge sheet, everything is.
Tomorrow. ನಾಳೆ ಬರ್ತಾರಂತ.
Great.
ಬರ್ತಾರಂತ.
Sorry, some inconvenience, I could not come. I'm sorry.
Tomorrow. ಇಲ್ಲ, 2013 ಏನು liability dispute ಇದೆ. ಯಾವತ್ತು ಬೇಕು? After vacation.
Lord, may I make one submission, my lord?
Ramesh be deleted since Ramesh Benny has entered appearance. ಪ್ರಕಾರ ಅರ್ಧ ಗಂಟೆ ಸಾಕು, ಅವ್ರಿಗೇನೋ ವೆಕೇಶನ್ ಅಂದ್ರೆ ಚೇಂಜ್ ಆಗುತ್ತೆ ಅಂತ.
Lord, may I make one submission, my lord?
Yes.
Serial number 47, our appeal is dismissed, my lord. I have deposited 25,000 rupees. The amount will be transmitted to tribunal.
Done.
Please.
Next week. Next Monday. Whom do you appear for? After vacation. Right? So, O&M company is disabled. You will not be disabled. If you are no, only if the wakalat is filed by O&M company, then there's no disability. Very large ಕೊಡ್ತಾರಂತೆ after vacation. Hello? 70? After vacation ಬರ್ಲಿ ಬಿಡಿ. After vacation. All of them will be repeated next week, unless all of you agree for some disposal. All after vacation next week. Yes. After vacation. 39. ಅವ್ರು ಕರ್ಕೊಂಡ್ ಬಂದ್ರೆ ಮಾಡ್ತೀನಿ, ಅವ್ರು ಒಪ್ಕೊಂಡ್ರೆ. ಯಾವತ್ತಿಗೆ? ಸಿಲ್ ನಂಬರ್ ಟೈಮ್ ತಗೊಂಡ್ರಲ್ಲ. Yep. Someone to do around 90%. Not a quarter.
Sir, hello, madam, after vacation, Allah.
Look at it. ಏನಕ್ಕೆ? ಹೌದು. ಕಸ್ಟಮರ್ 2 ಅಲ್ಲ ಯಾರದು? ಅವ್ರಿಗೆ ಹೇಳಿದಾರ ನಾರಾಯಣ ಸ್ವಾಮಿ ಅವ್ರು ಬರ್ಲಿ ಬಂದ ಟೂ ಆಮೇಲೆ ಸಿಕ್ಸ್ಟೀನ್ ಇದಾರ ಅವರು ಮುನ್ರಾಜು ಅಂತ ಇದೆ. ನೋಡಿದಾರೆ ಬರ್ಲಿ ಅವ್ರು ಏನ್ ಮಾಡಿ ವೆಕೇಶನ್ ಬರ್ಲಿ ಬಿಡು. ಡಿಲೇ ಕಂಟ್ರೋಲ್
30 in this case, my lord, respondent number 1 to 4, my lord. Balance amount to transfer ಹಾಕಿದ್ದೀನಿ. ಡಿಸ್ಮಿಸ್
ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೆಮೊ ಹಾಕಿದ್ರಂತೆ ಆ ಕಾಸು ತಗೊಳ್ಳಿ ಅವರು. ಹಾ ಪೂರ್ತಿ ಅಮೌಂಟ್ ಡಿಪಾಸಿಟ್ ಮಾಡಿ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೈಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ my lord.
Reason stated in IA 1/2022. The delay of 712 days in filing and recalling of the petition and the order dated 11/2/2020. Main main. ಏನ್ ಗ್ರೌಂಡ್ The insurer is an appeal challenging the sum of rupees 8,12,000 awarded for death of Bhagyamma. The tribunal for assessing the compensation has determined the income of the deceased at rupees 12,000 and has applied the multiplier of 11 and awarded the sum of rupees 7,92,000 towards loss of dependency after deducting 50% towards the personal living expenses of the deceased. In my view, there is no infirmity in the determination compensation by the tribunal. I see no ground to entertain this appeal. The bill is therefore dismissed.
Amount in deposit transfer.
ಮಾಡ್ತಾರೆ.
Yes.
Seal number 31.
Kumar. ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೀನಿ ನೋಡೋಣ ಇಲ್ವಾ ಸೀತಾರಾಮರಾವ್ ಮೋಹನ್ ಕುಮಾರ್ ಏನ್ ಮ್ಯಾಟ್ರ್ ಇದು ಏನ್ ಮ್ಯಾಟ್ರ್ 163 ಏನ ಸ್ವಾಮಿಯವರೇ ಈ ಬಾಲಕೃಷ್ಣನ್ ಕೇಸಲ್ಲಿ they refer to the occupants of the car. They would also be covered under the policy anta. Would it exclude the driver? No, ಇದು 163 ಅಲ್ಲಿ ಓನರ್ ಕಮ್ ಡ್ರೈವರ್ ಪ್ಯಾಕೇಜ್ ಪಾಲಿಸಿ ಆಗಿದ್ರೆ ವಿಲ್ ನಾಟ್ ತಪ್ಪಾಗಲ್ಲ ಪಿಲಿಯನ್ ರೈಡರ್ಗೆ ಕೊಟ್ಬಿಟ್ಟು ಕಾಸ್ನ ಅಲ್ಲ ನಮ್ಗೆ ಕಾಂಪ್ರೆನ್ಸಿವ್ ತಗೊಂಡ್ ಆಕ್ಟ್ ಓನ್ಲಿ ಪಾಲಿಸಿಗೆ ಬರೀ ಥರ್ಡ್ ಪಾರ್ಟಿ ಲಯಬಿಲಿಟಿ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಬಟ್ ಕಾಂಪ್ರೆನ್ಸಿವ್ ತಗೊಂಡಾಗ ಬರೀ ಪ್ರಾಪರ್ಟಿಗೆ ರಿಸ್ಟ್ರಿಕ್ಟ್ ಮಾಡೋದು ಸರಿನಾ ಅಂತ But the word they use there is occupants anta. The word used in that IIT circular is occupants. So then ಅವನಲಿಸಿ ಮಾಡಿದ್ರೆ ಓನರ್ ಕಮ್ ಡ್ರೈವರ್ ಇದಕ್ಕೂ ಆಗತ್ತಲ್ಲ ಅಂತ ನಾನು ಯೋಚನೆ ಮಾಡ್ತಾರೆ ಯಾಕಂದ್ರೆ ಎಕ್ಸ್ಟ್ರಾ ಪ್ರೀಮಿಯಂ ಕೊಟ್ಬಿಟ್ಟು ಯಾರು ಕಾಸು ಕೊಡ್ತಾನಲ್ಲ ಅವನೇ ಕವರ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ Million rate is not a third party, but yet nevertheless, for the purpose of a package policy, he is considered as I have a doubt because of the word used occupants. Again, this let us see, take advantage. Stop it. ಅಂಗಡಿ ಅವರೇ ನೋಡ್ರ ಮೀಟ್ ಮಾಡಿದ ಅಂಗಡಿ ಅವ್ರನ್ನ ನಾಳೆಗೆ ಹಾಕೊಳ್ತೀನಿ, ಒಂದ್ಸಲ ಹೇಳಿ ಅವ್ರು ನಾಳೆ ತಗೊಳ್ತೀನಿ. ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಬ್ರೀಫ್ ಪಾಯಿಂಟ್ಸ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೆ. ಮಹೇಶ್ ಅವರೇ ಅವ್ರದ್ದೇನು ಅಪ್ಪೀಲು? ಲೈಬಿಲಿಟಿ ಏನಕ್ಕೆ? 63 ಏನ? ಓನರ್ ಕಮ್ ಡ್ರೈವರ್. ಎಷ್ಟು ಇನ್ಕಮ್ ಎಷ್ಟು ಹೇಳಿದ್ರು? ಏಜ್ MFA 588/2011 by the insurer challenging the liability cited on it, while MFA 8521/2011 is by the claimant seeking for an answer. The claim petition was filed under section 163 capital A of the Motor Vehicle Act by the legal heirs of C. Vijay Kumar. It was stated that when Vijay Kumar was riding the motorcycle, he suffered a skid and had a consequential fall in which he sustained grievous injuries, to which he ultimately succumbed. The tribunal has allowed the claim petition in part and awarded only a sum of rupees 50,000. The insurer is an appeal contending that no sum could have been awarded to the LRs, and at any rate, the insurer could not be saddled with liability. The claimant are an appeal contending that the deceased was not the owner cum driver, and hence he would come within the insurance cover provided under 163 capital A. This court in the case of Within and others has already held that the borrower of a vehicle cannot be denied compensation if the accident out of use of the motor vehicle is established and an injury or death results from such an accident. It is held that if there is insurance cover to the vehicle which meets with an accident, the insurer would be liable to pay the compensation. In view of the said decision, the finding of the tribunal that the insurer would be liable only to a sum of rupees 50,000 under section 140 of the Motor Vehicle Act cannot be sustained, and the same is accordingly set aside. And it is held that the insurer would be liable for the compensation that the legal heirs of the victim are entitled to under the second schedule of the Motor Vehicle Act. The claimants contended that the deceased is earning rupees 40,000 per annum and was 26 years old. In my view, this claim of the claimants would have to be accepted, and accordingly it is held that the claimants would be entitled to some rupees 40,000 into 18 into 2/3 towards loss of as compensation under the second schedule. The claimants, they are claimants, Allah. Four brothers are. The claimants being the parents and the siblings of the deceased, each of them would be entitled to some rupees 44,000 towards loss of love and affection, and a further sum of rupees 33,000 under the conventional acts. C and nothing number code. 6% 8 weeks. Now time back antar. Next week antar. Next week back antar. Next week is vacation, after vacation only. Thursday. Srinivasan.
Ready, my lord. Ready, my lord. Ready, my lord.
Charge sheet ಹಾಕಿರ್ಲಿಲ್ಲ. ಹಂಗಾರೆ DSP acquits them. But at the same time they are maintaining the charge sheet also. ಇರ್ಬೋದು. ಚಾರ್ಜ್ ಶೀಟ್ ಒಂದ್ ಕಡೆ ಮಾಡ್ಕೊಂಡು ನಿಮ್ ಕಡೆ ಎಕ್ಸಾಮಿನೇಟ್ ಮಾಡಿದ್ರೆ ಯಾವ್ದು ಅಂತ ತಗೋಬೇಕು. How did the tribunal consider the report? Report was not placed before the tribunal. It was not considered by the tribunal. Was any action taken against the sub-inspector? Because this is only on the basis of his assertions. He has not examined anybody when he gives his report. He has not examined the driver of the lorry. Nobody is examined. The report was right. Did he make any investigation at all? ಅಲ್ಲ ಮರುವಳಿಕೆ ಅದೆಲ್ಲ ಫ್ರಾಡ್ ಒಪ್ಕೊಳ್ತೀನಿ ಬಟ್ ಈ ರಿಪೋರ್ಟ್ ಒಪ್ಕೋಬೇಕು ನಾನು ಅಂತಂದ್ರೆ I am more than you, Mr. Krishna. I am worried about such kind of reports. They virtually exonerate the accused. If this report is produced before the criminal court, ಆಯ್ತು. But what? Suppose I place reliance on this. I am virtually acquitting that person there in the criminal trial. Isn't it? How can the police officers do this? They accept a complaint from you. They have filed a charge sheet. By this report, they are virtually saying that the charge sheet is bad. But Nanage, I am worried about the fact that these kind of reports will virtually ಪೊಲೀಸರು ಹಿಂಗೂ ಹೇಳ್ತಾರೆ ಹಂಗೂ ಹೇಳ್ತಾರೆ ನಾವು ಯಾರು ನಂಬೇಕಂಗಾರೆ? Because this report is published, is prepared without even hearing that sub-inspector who investigated the matter. It is his assumption that ಇವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರ ಈ DCP ನ SP ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರ ರಿಪೋರ್ಟ್ ತಯಾರಿಸಿದ್ರಲ್ಲ SP has he been examined? Who is he?
RW2.
DYSP. And that's what the other case also held. They issue a report like this and they still prosecute the accused. Wala. The report bandi takshana, they should have withdrawn the charge sheet, saying that the charge that we have made is incorrect. You don't prosecute that person. They give you one report saying that this charge sheet is bogus. And at the same time, they prosecute that person also. And it ends in an acquittal. There's a trial that is held. That means till the end, the prosecution said that that person had committed the offense. But they give you a report saying that he has not committed any offense. Which of the two should I realize? They have to prove the charge sheet. To make a comment on this report, which has been prepared without hearing the investigating officer, without examining the witnesses whom he had cited, is a bit of a dangerous. Now, our MSCT bitbudi. No, I'm not on MSCT their approach. I'm concerned with the fact that the prosecution went on till the trial took place. So on what basis? I'm not inclined to accept this report. He has not examined even he has not even summoned the investigating officer. He summons the accused. No, the fact that it went to trial means the police, the IGP or whoever did not accept this report. If you had accepted this report, you would have directed withdrawal from prosecution. So long as the prosecution continues. Now, suppose imagine a situation where that I can rely upon such a report to reverse the finding of the tribunal. He was taken to the hospital immediately. The accused was taken to the hospital immediately. What did the owner say here?
Owner has admitted.
Owner has admitted.
Yes, madam.
Where?
Judgment internal page 3, madam.
The owner admits this. Owner admits this. ನೀವು collusion ಅಂತೀರಾ? Collusion ಅಂದ್ರೆ then sue them and recover the loss that is caused to you for committing a breach of the statutory provision and their policy condition. Sue them. Therefore, there is a glaring omission. If you go to the court and establish that when they amended the act, if they had said it can be presumed there's collusion, if 130% is not complied with, you're right. We are not dealing with a third party's claim. This is a violation between the two of you. Correct. Any breach between the two of you should not affect the claimant. If you establish it and declare it, go and file. If you can establish that you have a right to recover compensation because of violation section 34 in law, you're at liberty to do something. I will not give a finding, then nothing remains. That is a ground that you have to establish separately. You go to the civil court and file a suit. Let us see what happens. If you can establish there is a statutory obligation, Okay. You are only acting as an indemnifier. If the indemnification is by virtue of a policy which you think was misused and you are not actually liable for indemnification, Madi. ಇದರಲ್ಲಿ fraud ಹೇಳ್ತಿಲ್ಲ ನೀವು. You are saying you have a right to recover on the fraud under ille established. Then I will hold that you have not established fraud here. That is all. ಸುಮ್ಮನೆ ಪೊಲೀಸರು ತರಲೆ ಮಾಡ್ತಾರೆ. ಅವನ್ ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವ್ನ್ ಕಾಸಿಸ್ಕೊಂಡು ಅವನೊಂದ್ ಮಾಡಲ್ಲ, ಇವನೊಂದು ಕಾಸು ಇವನೊಂದ್ ಮಾಡ. ಯಾರು ಅವ್ನು ಇದನ್ನ ಅಕ್ಯೂಸ್ ಇದನ್ನಲ್ಲ ಅವ್ನ್ ಕೊಟ್ರ ಅಕ್ಯೂಸ್ ಇಲ್ಲ, ನೀವೇ ಡೆಫಿನೇಷನ್ ಬೇರೆ ಇಲ್ಲ. ಒಂದು DS ಒಂದು SP ಕರ್ಸ್ಬಿಟ್ಟು this person is charge sheeted is the accused in a criminal case. The DCP summons him, records a statement and says yes, the charge sheet against you is wrong. That is the effect. He was the accused. He gets the benefit. He produces that report to the prosecution. And again, I have serious doubts about this person's integrity. Having called only the accused, he does not call anybody else. Then I will hold that the report is not accepted by the superiors if the prosecution has gone on. Who else was examined here to establish the accident? This gentleman was not examined, Sidhu, before the criminal court. They have not examined this this witness. He claims that he has seen this accident. PW2. No. PW3. ಅವನು ಕ್ರಾಸ್ ಮಾಡಿದ್ದೀರಾ? ಇವನನ್ನು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ. ಮಾಡಿದ್ರು. They have examined the cleaner who was traveling in the lorry as PW3. He says the accident occurred. And he has not been examined in the criminal court. The other two eyewitnesses cited here are not examined in the trial before the criminal court. Open cross-examine madilla. ಇದ್ರ ಬಗ್ಗೆ ಏನ್ ಮಾತಾಡಲ್ವ ನಾನು? He only goes on the ground that the number was given subsequently. Therefore, the entire thing is doubtful. He has not examined the driver. He has not examined the cleaner of the lorry. ಯಾವ್ದು ಓದ್ತಿದ್ದೀರಾ? ಎಲ್ಲಿ? ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ. ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ. ಅಲ್ಲ, ನೀವು ಈ ಟ್ರೈಬ್ನಲ್ ಕೊಟ್ಟರೆ ನಾವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್ ಮಾಡಿಲ್ಲ. ಟ್ರೈಬ್ನಲ್ ಅಲ್ಲಿ ಎಕ್ಸಾಮ್ ಮಾಡೋದನ್ನ ಇಬ್ರು 3 ಜನ ಮಾಡಿದ್ದಾರೆ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ದ ಕ್ಲೀನರ್ ವಾಸ್ ಟ್ರಾವೆಲಿಂಗ್ ದಟ್ ಲಾರಿ. ಅಲ್ಲ, 100ಕ್ಕೆ 100 ಡೌಟ್. ಬಟ್ ಈ ಎವಿಡೆನ್ಸ್ ಏನ್ ಮಾಡ್ಬೇಕು ನಾನು? I'll be honest, I don't accept that report at all. That is a very perfect report. I will say that's an irregularity. I will hold that report does not inspire confidence. If you want, I'll lay down the law that you cannot rely upon such a report contrary to the charge sheet. ಇದು ತುಂಬಾ ಡೇಂಜರಸ್. you go behind the back of the accused, you go behind the back of the claimant. Without hearing anybody, you secure a report from the police authorities saying that no offense is committed, no accident. And because it comes from higher officer, we have to blindly accept it.
Expected to examine claimant also, the owner also, provided they are on the hand.
I'll put it like this. You have a grievance against a charge sheet that is filed. You believe that there's no accident, therefore you go and complain to the higher authorities. Charge sheet is bad. Correct. This is what you would do. But before the trial, no. We will ignore the entire criminal proceedings. We will take this case where they examine the cleaner, 2 eyewitnesses, for whatever it is worth. These 3 people have not been cited as witness there. Therefore, it goes to show the kind of investigation that the police have done. In the manner and try, the minister tried to prove the allegation. They're obviously trying to help the driver. That's why they get hold of people who don't see, who turn hostile. ಇಲ್ಲಿ ಇವರು ಕ್ಲೇಮೆಂಟ್ಸ್ ಬಂದ್ಬಿಟ್ಟು ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ನಾವು ರಿಜೆಕ್ಟ್ ಮಾಡಬೇಕು ಬಿಕಾಸ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಯು ವಾಂಟ್ ಅಸ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ವಾಟ್ ಎವರ್ ದಿ ಪೊಲೀಸ್ ಸೇಸ್ ದ ಟ್ರೂತ್. ಒಬ್ಬರು ಮಾಡಿಲ್ಲ. But I think you should do something about this. This is not the way to establish implication. I don't know. You are the expert. You should come out with ways and means. ನೀವು ಅದು ಎಲ್ಲ ಬರೀ ಶಾರ್ಟ್ ಕಟ್. DSP ಹತ್ರ ಹೋಗೋದು. You will have to establish independently that accident did not occur. There are ways and means of proving it.
As an investigator, private investigator to do it,
you could have summoned the driver of this lorry. You could have summoned the cleaner just like they did. ಅವ್ರದ್ ಬಿಡಿ, ನಿಮ್ ಡಿಫೆನ್ಸ್ ನಿಮ್ ಕಾಸ್ತಾನೆ ಹೋಗ್ತಿರೋದು. ನಿಮ್ ತಾನೇ ಇಂಟ್ರೆಸ್ಟ್ ಇರಬೇಕು. ನಿಮ್ ತಾನೇ ಲಾಸ್ ಆಗೋದು. MSCD ಏನಾದ್ರು ಹೋಗುತ್ತಾ? You also don't want to take responsibility for your money. Public money antra, you don't want to safeguard that. ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಸುಮ್ಮನೆ ಮೋಟರ್ ವೆಹಿಕಲ್ ಆಕ್ಸಿಡೆಂಟ್ ಎಲ್ಲರಿಗೂ ಕೊಟ್ಬಿಡಿ. ಸುಮ್ಮನೆ ಯು ಕ್ಯಾನ್ ಡೂ ಇಟ್. ಯು ಡೋಂಟ್ ಹ್ಯಾವ್ ದಿ ಎಕ್ಸ್ಪರ್ಟೀಸ್. ಎಕ್ಸ್ಟ್ರಾ ಪ್ರೀಮಿಯಂ ತಗೊಳ್ಳಿ, ಕಂಡೀಷನ್ಸ್ ಹಾಕ್ಬಿಡಿ. ಆಕ್ಸಿಡೆಂಟ್ ಆಯ್ತಾ ಕೊಟ್ಬಿಡಿ. ಯಾಕೆ ಬೇಕಿದ್ದು? ನಿಮ್ ಕೈಲಿ ಹೆಂಗಿದ್ರು ಆಗಲ್ಲ. ಪೇನ್ ರಿಕವರಿ ಏನು ಮಾಡಲ್ಲ ನೀವು. ಸ್ಟ್ರಿಕ್ಟ್ ಲಯಬಿಲಿಟಿ ಮಾಡ್ಬಿಡಿ. ಸುಮ್ಮನೆ ಇದು ಯಾಕೆ ಬೇಕು? ಯು ಆರ್ ವೇಸ್ಟಿಂಗ್, ಯು ಆರ್ ಕ್ಲಾಗಿಂಗ್ ಅಪ್. ಮಾಡಿ, ದಯವಿಟ್ಟು ಮಾಡಿ. ನೀವ್ ಹೇಳಿದ್ರೆ ಮಾಡ್ತಾರೆ. The insurer is in appeal, challenging the award of rupees 6,32,000 granted to the legal heirs of Shankara, who was killed in a motor vehicle accident. The insurer contends that the entire story of Shankara being hit by the insured vehicle is palpably false. In reliance of this argument, learned counsel seeks reliance on a report of the police superintendent, which was submitted to the Director General of Police, dated 24/11/2007. It is stated that as per this report, which is submitted to the DGP, the falsity of the case put forth by the claimant was clearly established, and the tribunal has fundamentally ignored this report and has proceeded to come to the conclusion that the accident stood proved by virtue of the charge sheet that had been filed against the driver of the insured vehicle. A perusal of the investigation report said to have been submitted by the SP to the DGP reads as follows. The relevant portion reads as follows. As could be seen from the said report, the SP basically doubts the entire case put forward since the vehicle number had not been mentioned at the time of lodging of the complaint. The SP ultimately states that this was a fit case to initiate disciplinary proceedings against the investigating officer. However, whether this recommendation of the SP has been accepted or not is not forthcoming. If the SP had concluded that the charge sheet laid against the driver of the insured vehicle was false, as a natural consequence, the police ought to have withdrawn the prosecution against him. However, it is not in dispute that the police continued to prosecute the driver of the insured vehicle, and he was ultimately acquitted in the criminal court as the witnesses there turned hostile. The fact that the investigation continued even after the report of the SP points to the fact that in all probability the report was not accepted by the DGP. This is because if this report had been accepted by the DGP, as a natural consequence, the prosecution ought to have been withdrawn against the accused. In my view, therefore, no credence can be attached to this report of the SP upon which strong reliance is placed by the counsel for the insurer. In the present case, before the tribunal, the claimants examined Sidhu, titled PW2, GK Sundaresh, PW3, and MP Sunil Kumar as PW4. Sidhu stated that he witnessed the accident caused by the insured vehicle. Sidhu was not cross-examined by the insurance company. PW3 Sundaresh also reiterated that he had witnessed the accident. He has been cross-examined with suggestions that he knew the deceased and was trying to help him. PW4 was examined and he claimed that he was a cleaner working in the lorry which caused the accident. He has also been cross-examined by the tribunal, by the counsel for the insurer. The evidence of two eyewitnesses and the cleaner indicate that the insured vehicle was involved in the accident. These depositions, if read in the context of the owner's objections, in which he admitted the occurrence of the accident, would lead to the only conclusion possible. That is, the vehicle in question was involved in the accident. The tribunal, though did not consider exhibit R1, it has nevertheless considered the evidence and has come to the conclusion that the insured vehicle was involved in the accident. It has taken note of the evidence of PW4, the cleaner, who stated that the lorry, the insured lorry, did hit the deceased, despite the fact that the deceased was visible to the driver of the lorry. In my view, in the light of this evidence recorded by the tribunal, the argument that no accident had occurred and the vehicle was implicated cannot be accepted. I find no reason to interfere with the order of the tribunal, and the appeal is therefore dismissed. Mahesh ಅವರೇ,
ಓ ಮಹೇಶ್,
liability ಏನಿಲ್ವಾ? ಮಹೇಶ್ ಅವರೇ, ಏನ್ ಗ್ರೌಂಡ್ ಮೇಲೆ? What made it the accident? What is? Correct. 10. In injury case, huh? Yeah, paragraph. Yeah, which paragraph? ಎಲ್ಲಿದೆ cross examination? ಏನ್ ಇಂಜುರಿ ಆಗಿರೋದು? ಅವ್ರನ್ನ ಟ್ರೀಟೆಡ್ ಡಾಕ್ಟರ್ ಇಲ್ಲ ಬೇರೆ ಯಾರು? How old was she? This appeal is preferred by the claimant challenging the dismissal of her claim petition. The tribunal has dismissed the claim petition mainly on the ground that the registration number of the vehicle had been initially registered as has been recorded as KA03 6000, and thereafter the vehicle number was changed to KA34 6000, and this was done with a deliberate intention to help the claimant. The claimant had filed a petition contending that that while she was trying to get into the maxi cab, the driver abruptly moved the vehicle, and as a result, she lost control and fell down from the maxi cab and sustained previous injuries. The insurer, in his objections, at para 10, has stated as follows. PW1, the claimant, was also cross-examined and to the suggestions made by the insurer's counsel, the claimant has replied as follows. So, the line of questioning adopted by the insurer itself suggests that the claimant was attempting to board the bus and the accident occurred due to her negligence. The objection statement as well as the suggestions clearly establish that the insurer had admitted the accident. In the light of the admission of the insurer, the reliance on the recording of registration number to non-suit the claimant by the tribunal would be incorrect, and the same is accordingly set aside. As the accident is of the year 2008, in my view, it would be appropriate to determine and quantify the compensation instead of remanding the matter only for this purpose. Next, the doctor who examined the claimant stated that she had suffered a fracture of the shaft of the right humerus with radial nerve palsy. He has ultimately opined that she had suffered 20% disability to the whole body. In my view, with regard to the nature of injuries sustained by the claimant, it would be appropriate to determine the disability at 15%, as the accident is of the year 2008 and there is no evidence to establish the actual income. The sum of rupees 4,500 fixed by KSLSA for accidents of the year 2008 is adopted. Consequently, the claim will be entitled to sum of rupees 4,500 to 12, 35 years multiplied 35, 16 into 10, 15% towards loss of future earning. In my view, since the claimant suffered a fracture of the humerus, it would be appropriate to award a sum of rupees 40,000 towards pain and suffering and rupees 30,000 towards loss of amenities. Medical bills and idea. The claimant has produced medical bills the tune of 8,091. He is therefore awarded a sum of rupees 8,091 towards medical expenses. The claimant was hospitalized for 13 days. So therefore be appropriate to award a sum of rupees 15,000 towards nutrition, conveyance charges and attendant charges. Now the claimant will be followed. Admit 142 days.
ನಾವು ನೋಡಿರುತ್ತೇವೆ ಆತನ ಪರಿಚಯ ನನಗೆ ಆತನ ಹೆಸರು ಕುಮಾರ ಮುಂಚಾಗಿತ್ತು. ಈ ಘಟನೆ ನಡೆಯುವಾಗ ಸಂತೆ ಸುಮಾರು 6:45 ಆಗಿರಬಹುದು. ಈ ಮುಂದಿನ ಕ್ರಮವನ್ನು ಕೈಗೊಳ್ಳಬೇಕು. ಈ ನಂಬರ್ subsequently 2 days after
K14E 1242 ಹೇಳಿಲ್ವಾ? ಯಾವ ನಂಬರು? ಯಾವ ನಂಬರ್ ಕೊಟ್ರು? FIR ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ K14E 1242 ತಾನೆ? K15 You are the insurer of this KA15H9341. What does the tribunal say for the discrepancy? Vera?
On the basis of the police report, the police is responding. First responding to whatever vehicle in the vehicle. But it also has been needed as a taking forward. After cross-examination, but it's next forward and not day 14 anything forward. 15, 14, after they own
What is the claimant? What is the application? Agriculturist. 58 years. So that is your contention. FIR ಅಲ್ಲಿ ಒಂದು ಆಮೇಲೆ ಒಂದು. Where is the FIR? FIR is exhibit. What does does he know how to read and write? This gentleman, Clement. Clement, who prepared the complaint? ಈ ಹೇಳಿಕೆಯನ್ನು KMC ಆಸ್ಪತ್ರೆಯಲ್ಲಿ 8/8/2003 ಪಡೆಯಲಾಯಿತು. Did you examine this head constable? Correct. But the next police notice, they themselves changed the number to KF14 H10. Exhibit. What was the injury suffered by the claimant? The damage ಏನಾಗುತ್ತೆ motor. But if the driver of the two-wheeler admits the guilt, then did you establish that whether the other vehicle that they mentioned in the FIR had no insurance? The FIR. See, you did not examine the head constable who recorded the statement. This was recorded in the hospital. So this gentleman should have come and said, yes, this was the number given. I have recorded faithfully. Then they also produced documents issued by the very same police. If you want me to accept whatever is given with the police, I will also have to accept exhibit P1. It's also a statement, notice given to the claimants about the occurrence of the accident, the details to enable them to file a claim petition. This is also true then. If this is true, correct. It is not that the claimant wrote it in his own hands. He was in the hospital. The statement is recorded. Suppose this head constable had committed a mistake in recording the number in this complaint, then what should be the consequence? So therefore, this statement that is recorded may be completely wrong. If you had established the K14E2 1 to 4 na record summon ಮಾಡಿಸಿ ಅದಕ್ಕೆ ಇನ್ಶೂರೆನ್ಸ್ ಇಲ್ಲ ನೋಡಿ ಅದಕ್ಕೋಸ್ಕರ ಇಂಪ್ಲಿಕೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ there is something in what you say. ಯಾರು? ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಿ ನೀವು? ಅಫಿಷಿಯಲ್ ಅವ್ರಿಗೇನು ಗೊತ್ತಿರಲ್ವಲ್ಲ? ಎಲ್ಲಿದೆ? ಶ್ರೀನಿವಾಸ್ ಪ್ರಸಾದ್. ನಿಖರವಾಗಿ ನಾನು ಹೇಳಲು ಬರುವುದಿಲ್ಲ. ಗಾಡಿ ನಂಬರ್ that is what is mentioned in the police notice, K14H1 9341. So therefore, when the lawyer K14 ಕರೆಕ್ಟ್. ಅವ್ರಿಗೆ ಪೊಲೀಸ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದು KA-14 ಅಂತ, ಅದಕ್ಕೆ ಲಾಯರ್ KA-14 ಅಂತಾನೆ ಹಾಕಿದ. ಆಮೇಲೆ ಗೊತ್ತಾಯ್ತು KA-15 ಅಂತ, ಅದಕ್ಕೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಅವನ ಬಗ್ಗೆ ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರ ನೀವು ತಿಮ್ಮಪ್ಪ ಗೌಡನ ರಿಗಾರ್ಡಿಂಗ್ ದ ನಂಬರ್? Where is he plead guilty alliದೆ? ಹೇಳ್ತಿದ್ರೆ ಸುಸಂಬರಿ yes But the driver of KA-15H-934 was prosecuted, ತಾನೆ? The driver of KA-15H-934 was prosecuted. That gentleman was prosecuted and he pleads guilty. Collusion. ಒಂದು ಕೈಯಲ್ಲಿ ಬರ್ಕೊಟ್ಟಿದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ನನ್ಗೆ ಅಷ್ಟು ತೊಂದರೆ ಆಗ್ತಿರ್ಲಿಲ್ಲ. ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಸ್ ರೆಕಾರ್ಡ್. ನೀವು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಇದ್ದಾಗ ನೋವಲ್ಲಿ ಇದ್ದಾಗ ನೀವು ಬಂದ್ಬಿಟ್ಟು ಓದ್ಬಿಟ್ಟು ಲಾಯರ್ ಹತ್ರ ಒಪಿನಿಯನ್ ನೋಟ್ಸ್ ಏನ್ ಮಾಡ್ತೀವಿ? ಫ್ರಾಕ್ಚರಾ? ಇವಾಗ ನನಗಿಂತ ಜಾಸ್ತಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇದೆ. ಪೊಲೀಸ್ ಹಾಸ್ಪಿಟಲ್ No, you could have trapped. Like, no, for us to punish him. If he had secured that motorcycle, subjected that to cross-examination, and established that there was no insurance and this was the fraud that was being played, then dismissal with costs. You don't do anything. You keep quiet. Then you want to rely upon the weakness of the victims to say, I will throw you out. A constable. He gives a statement that is recorded with the police constable whom you should have examined to establish that that was the actual statement that he gave. It is a requirement ಅಂತ ಹೇಳಿದಾರೆ. ಇಲ್ಲಾಂದ್ರೆ claim petition ವಜಾ ಮಾಡಿ ಅಂತ ಏನು ಹೇಳಿಲ್ಲ ಅವರು. You can seek for dispensing that they don't register an FIR. You can't force the police to register an FIR for a claim. If they don't, ಅವ್ರೇನು ಸತ್ಯರಕ್ಷಣೆ ಕೊಡಲ್ಲ. They don't. They want to help a powerful accused. Normally, ಅಲ್ಲ abnormally. ವಿಜಯ್ ಕುಮಾರ್ ಕೇಳಿ, ಒಂದ್ ದಿನ ಫುಲ್ ಲೆಕ್ಚರ್ ಕೊಡ್ತಾರೆ. ಏನ್ KSRTC ಕಂಪ್ಲೇಂಟ್ ಮತ್ತೆ ನಾನ್ ದಿನಾಲು ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್. ಅವ್ರು ನನ್ಗೆ ದಿನಾಲು ಕೇಳಿಸ್ಕೊಳ್ತೀನಿ ಆರ್ಗ್ಯುಮೆಂಟ್. ಅಲ್ಲ you should also share my agony. ಅಷ್ಟೇ ಅಲ್ವಾ? ಅಷ್ಟೇನೆ ಕೇಸಲ್ಲಿ. ಕಾನ್ಸ್ಟೇಬಲ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರೆ ಈಗ ನಾಟ್ ನೌ. ನೀವು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ, ಮಾಡಿದ್ದಿದ್ರೆ but unfortunately for you that the driver of the particular vehicle is admitted his guilt. So in law, there's a person who says, I have committed a mistake, we impose a fine upon me. In another set of proceedings, I'm saying that no, that gentleman never committed that crime. Preponderance of probabilities. MFA 5116/2012 is by the insurer, while MFA 4662/2012 is by the claimant seeking for enhancement. The insurer is an appeal contending the tribunal adhered in believing that an accident occurred as a result of the use of the insured vehicle. In order to support this argument, Learned Counsel relies upon the complaint recorded on the basis of the statement given by the claimant while he was hospitalized, in which it has been recorded that the accident was caused by KA 14E1242 He submits that when the claimant himself had given the number as KA14E1242, so the subsequent assertion that vehicle bearing number KA14H9341 had caused the accident, and the subsequent amendment to this number as KA15H9341 clearly establishes that the vehicle was not at all involved in the accident. It is to be stated here that the claimant did not lodge the complaint while the claimant was hospitalized in KMC hospital, the head constable of Manipal police station is stated to have recorded the statement on the basis of which an FIR was registered. The insurer examined this head constable to prove that the claimant had narrated that vehicle bearing KA number 14E1242 was involved. The argument of the insurer would have some credence. It is to be stated here that the rider of the insured vehicle bearing K15H9341 was charged with an offense punishable under section 279, 338 in CC number 880/2003. And in these proceedings, the rider pleaded guilty and was imposed a fine. In my view, since the rider of the insured vehicle himself pleaded guilty of the rash and negligent driving, the entire argument of the counsel for the insurer that the vehicle was not involved in the accident falls to the ground. I therefore find no grounds to interfere with the reasoning of the tribunal, and the appeal of the insurer is therefore dismissed. As regards enhancement, the tribunal has awarded a sum of rupees 88,960 in respect of a fracture. 86,960 for a fracture, for a fracture suffered by the claimant. In my view, in regard to the medical evidence on record, the sums awarded by the tribunal is just and proper and do not call for any answer. The appeal of the claimant is also accordingly dismissed. What a deposit. ಅಲ್ಲ ನೀವು ಮಾಡಿದ ತಪ್ಪು ಸ್ವಲ್ಪ ನಿಮ್ಗಾರು ಪೆನಲ್ಟಿ ಬೀಳುತ್ತಾನೆ. FIR 20 ರೀಚ್ ಆಗಲ್ಲ ಮೋಸ್ಟ್. ಓ ಮಹೇಶ್, ಇನ್ ಅವ್ರದ್ದೇನ್ ಕೇಸ್?
Serial number 6, my lord.
Yes.
Serial number 6, I am the appellant, my lord.
ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು? MF 6289 Same accident, 2 cases. How? 172 is
My appeal, my lord.
The same accident. It's a pillion rate.
Yes, sir.
ಅಲ್ಲ ಸ್ಕೂಟರ್ ಅಲ್ಲಿ ಯಾರು ದಿಸ್ ಜೆಂಟಲ್ಮನ್ ವೆಂಕಟೇಶಪ್ಪ ಅಂಡ್ ಇಸ್ ಬ್ರದರ್ ಇನ್ ಲಾ ಚಂದ್ರಪ್ಪ.
Chandru.
Both of them were passengers in this two-wheeler. This was hit by another two-wheeler.
Yes, madam.
ಚಾರ್ಜ್ ಶೀಟ್ ಯಾರ ಮೇಲೆ ಹಾಕಿದ್ರು? ಹೀರೋ ಹೋಂಡಾ. ಅವ್ರಿಗೇನ್ ಏಟ್ ಆಗ್ಲಿಲ್ವಾ? ಅವ್ರೇನ್ ಕ್ಲೇಮ್ ಹಾಕ್ಲಿಲ್ಲ? ನಿಮ್ ಗಾಡಿ ಯಾರು ಚಾರ್ಜ್ ಶೀಟ್ ಯಾರ ಮೇಲೆ ಹಾಕಿದ್ರು? ಅಲ್ಲ ಡಿಸೀಸ್ ಮೇಲೆ ಹಾಕಿದಾರ ಇಲ್ಲ ಚಂದ್ರಪ್ಪನ ಮೇಲೆ ಹಾಕಿದಾರ? So you were driving. Intersection. Intersection ಆಗಿದೆ. Intersection ಆಗಿದೆ accident.
Middle of the road, my lord.
ಚಾರ್ಜ್ ಶೀಟ್ ನಿಮ್ಮ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ. Was he examined? Nobody was examined to prove the.
My lord,
What did he say? Chandru, then the evidence.
your lordship, the complaint is against that vehicle, my lord. It is against K43H5688. The first.
But charge sheet is against the driver of the Bajaj Chetak scooter, no alva?
Yes, my lord. Bajaj scooter is a rider and pillion rider. Both have sustained. Rider is died and pillion rider has sustained the grievous injuries, my lord. But the first complaint was filed against this K43H5688. But the police have charged it against the K04Q7165, in which the pillion rider and the deceased were going, my lord. Against that vehicle, the police have filed a charge sheet. On that basis, charge sheet, the Honorable Tribunal has dismissed the claim petition.
Dismissed?
Yes, my lord.
But he was a pillion rider.
Yes, my lord. I am the pillion rider.
ಇನ್ನೊಂದು ಕೊಡಿ 172 ಬರ್ತದೆ. ಸೊ ಒಂದೇ ಆಕ್ಸಿಡೆಂಟ್ ಅಲ್ಲಿ ಒಂದು ಡಿಸ್ಮಿಸಲ್ ಒಂದು
My case has been dismissed, my lord. I am the pillion rider, though.
ನೀವು ಪಿಲಿಯನ್ ಹಿಡಿದ್ರೆ ಇವ್ರು ನೀವು ಪಿಲಿಯನ್ ಹಿಡ ಅಂತಾರಲ್ವಾ?
Even in charge sheet also, I am the pillion rider. And even in evidence also, it has come, my lord. The rider was dead.
80-20, yeah. I'll maintain the same thing and award compensation.
My lord,
Injury.
Injury is sustained in our case. He is a painter, my lord, aged about 42 years, earning rupees 11,000 per month, my lord. Fracture of left patella and fracture of tibia and fibula of the left leg, my lord. And the disability is for 24.9% of the left lower limb, my lord. He was a carpenter, 12% whole body.
So 10%, whole body?
12%, my lord, as per the doctor evidence.
Treated doctor yaro? Nati treatment at Yalanka antira.
KK Hospital, Yalanka, but doctor is examined from the Boring Hospital.
I'll take 8%.
Yes. And carpenter than Nodkondo, 12% are reading as per the doctor evidence.
Medical bills produce our Darnor.
Yes.
MFA 5289/2012 is by the insurer challenging the award rupees 5,03,000 granted for the death of PM Venkateshwar. MFA 172/2013 is by the claimant who had suffered injuries in the very same accident, but had lodged a claim before a different tribunal, and that tribunal has dismissed the claim petition. The insurer basically contends that though the complaint was initially lodged against the rider of the two-wheeler, of the insured two-wheeler, the two-wheeler insured by the insurer, subsequently, the police had laid a charge sheet against the, and in this view of the matter, the tribunal could not have awarded any compensation. The author policy?
Composite negligence, sir. It can be held as a composite negligence.
The claimants produced the sketch as per Exhibit B6. This sketch indicates that the deceased and the claimant in MFA 172/2013 were going from Tindlu to Devnalli, which is a major road, and the insured motorcycle was coming from Yalanka, from Yalanka to Chaparkallu.
Chaparkallu.
Was going from Chaparkallu to Yalanka, which is a minor road. The sketch indicates that the accident occurred at the middle of the intersection. In the light of the fact that the accident occurred at the intersection, the tribunal was justified in attributing 20% negligence to the motorcycle in which the deceased was traveling, and 80% two-wheeler scooter, and 80% on the motorcycle which was being driven from two-wheeler Chaparkala to Lanka. It is to be borne in mind that the insured vehicle was trying to cross a major road, and he ought to have been cautious and proceeded to cross the vehicle intersection only after assuring himself that there was no other oncoming vehicle. And therefore, of the view that the reasoning by the tribunal, which granted compensation after attributing 20% negligence, scooter in which the deceased was traveling in MVC 8220/2010 is correct and does not require any interference. Since I have upheld the apportionment of negligence of the same accident in the ratio of 20:80, the claimant in MFA 172/2013 would be entitled to compensation, would be entitled to recover compensation of 80% from the owner of the insured vehicle.
My lord, I am the pillion rider, so it will become the composite negligence. So for me,
the question as to whether you're the pillion raider or you is the pillion raider is doubtful. So you accept this 20% and be satisfied. Because in that case,
yes,
it is
my
said
lord.
that he is the pillion raider.
Even in charge sheet also it is a pillion. I am the pillion rider, my lord. Even complaint also I am the pillion rider.
In the present case, the claimant contended that he was 42 years old and was a painter and had suffered a fracture of the left patella and of the tibia and fibula of the left leg. The doctor who assessed the disability was examined and he has stated that the claimant had suffered 12% disability to the whole body. In my view, since the treated doctor was not examined, it would be appropriate to determine the whole body disability at 8%. And since there is no proof to establish the actual income, the sum of rupees 5,500 fixed by KSLSA for the year 2010 is adopted. Consequently, the claimant will be entitled to sum of rupees 5,500 into 12. Just multiply this to 42 years to 14 into 8%. In regard to the multiple fractures sustained by the claimant, to be appropriate to award a sum of rupees 50,000 towards pain and suffering and rupees 40,000 towards loss of amenities. The claimant has produced medical bills to the extent of 1,620, and therefore the said sum of rupees 1,620 is awarded. Is the hospital?
Hospitalized for
ನಿಮಗೆ ಹಾಸ್ಪಿಟಲೈಸೇಷನ್ ಇಲ್ವಾ?
ಇದೆ hospitalized.
In regard to the fact that the claimant had suffered 3 fractures, it will be appropriate to award sum of rupees 20,000 towards food and nutrition, conveyance and attendant charges. And will be spent into the following sums. Since it is already held that the owner of the insurer of the motorcycle would be responsible to the extent of 80%, the claimant will be entitled to receive only 80% of the above mentioned compensation from the insurer.
Number 7.
Yes, Kumar. Yes, sir. ಏನು ಅವ್ರೇನು ಕಪಿಲ ಹಾಕಿರೋದು? How many people were there in the lorry? Window? ನೋಟ್ ಆಗಿತ್ತಾ? RC book ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಾ? ಪಾಲಿಸಿ ಇದೆಯಾ? ಪಾಲಿಸಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? These two appeals are by the insurer challenging the award rupees 1,42,600 and rupees 1,19,400 granted to the claimants for the injuries suffered by them in the accident which occurred on 11/5/2004. It was the case of the claimants that they were proceeding as loaders and unloaders in an open lorry which belonged to the first respondent and was insured with the appellant insurer. And while so traveling, the truck hit a cable wire across the road. Dashed it to an electric cable across the road. When they came in touch with the cable wire running across the road, and the said cable wire spiraled around their neck, and they fell down from the lorry and were dragged to a distance, and as a consequence suffered grievous injuries. It is a case of the insurer that having regard to these petition governments itself, it was clear that the claimants were traveling in the open space of the lorry, and therefore the insurer would not be liable. Rule 100 of the Karnataka Motor Vehicle Rules prohibits the carriage of passengers in a goods vehicle. However, as per the proviso, an exception is made in respect of bona fide employees of the owner or hirer of the vehicle to be carried along with the goods in the goods vehicle. It is also not in dispute that the owner of the vehicle had taken a policy which provided for compensation, which provided for the insurance company to cover the liability under the Workmen's Compensation Act to the employee, to two employees. So it is also not in dispute that the vehicle in question was a lorry, and had a carrying capacity of 6 alva 7. This view of the matter, the finding of the tribunal that the insurer was liable in respect of injuries suffered to the claimants who were employees being carried in the goods vehicle cannot be found fault with. I find no reason to maintain this appeal, and the appeal is accordingly dismissed.
Chandrasekhar, correspondent.
Next week. Nine. In round. ಆಗಲ್ಲ ಬಂದ್ರು ಹೋದ್ರು ಬೇರೆ ದೇಶ ಪ್ರಶಾಂತ್ Do not wait here. You just walk. You should not ask me. You just walk away. Are you appearing? Not appearing?
That's okay.
What does the policy say? Does the owner admit that he did not have a license?
So, owner is expert. We have taken this.
Case of death. Case of death. Case of death. Then how will they have possession of the driving license?
Because it's
Was the driver charge sheeted for an offense of not driving with the license? What happened? What happened? Is that a ground available to the employer under the WC Act? Then how do you establish that? How do you establish that? You have not established that you did not have a license. That is proof.
No, without driving license number, we are not able to prove also. We cannot take the comments to the RTO also because which RTO we have to take. Then we have to go, payments are the custody of the document. When we took a specific attention, there was no driving license. They have produced to the right of he has a driving. They have not done so. The burden lies on them. When we have taken a specific condition, what are they doing? They are the custodian of the law. She can produce to you. Even people that there is no harm for them, they are getting to.
So even if he had no license,
Yes, sir. If we have no driving license, as for the very nursing, the owner is having.
if it is admitted,
The owner is admitted. She can, the owner will be having the money of the driver.
so summoned the owner.
When we place expert in the we are
Someone.
we place expert.
Need the citation.
He is having the knowledge that the proceedings are going on. He received the sound and he places expert. This is having the knowledge about the proceedings. But the ratio, if you know,
Rashid was against deceased. Only section 3 and 4 ಎಲ್ಲಿದೆ? There is no charge sheet for violation of under section 3 and 4 of the Motor Vehicle Act. Then
the question is, he sees when the defendants are blamed, they are having the better knowledge about
so the charge sheet is proof that he had license. Or else they would have charged him with driving without license.
Well, if the driving license is there, let them produce before the court. So they are in the court. Let them produce. I don't have any ground to argue about it. Let them produce.
You should have summoned the records from the police and established whether there is a license or not. That having not done.
Instead of turning here and there, they are the best known witnesses because they have the more documents.
Can
They have the best known. They have
question of law frame ಮಾಡಿದ್ದಾರೆ. Question of law frame. Whether the commissioner for workmen's compensation could have exonerated the insurer of liability when the charge sheet, when the police had not prosecuted the deceased workman for driving without a driving license. It is not in dispute that the deceased, while being employed by the first respondent, had suffered an accident when he drove into a parked lorry, which resulted in his death. The commissioner has exonerated the insurer only on the ground that the driving vehicle driving license had not been produced by the claimants, would therefore have to be held that the deceased had no license, and as a consequence, the insurer cannot be saddled with any liability. It is also stated by the commissioner that the accident occurred due to the negligence of the deceased, as indicated by the charge sheet that had been filed against him, and therefore the employer was not liable. In a proceeding under the Workmen's Compensation Act, the negligence of the workman which caused the accident would not be a defense, not be a ground to non-suit the claim of the legal heirs of the workman. The finding of the commissioner in this regard is therefore improper and set aside. As far as the contention that the deceased did not possess a driving license, it is not in dispute that the deceased was charge sheeted by the police, and the police, while charge sheeting him, had only alleged that he was guilty of rash and negligent driving, that is under section 279 and 338 of the IPC. Since the deceased was not charge sheeted under section 3 and 4 of the Motor Vehicles Act, it have to be presumed that he did possess a driving license, and this aspect had also been examined by the police. The question of law is therefore answered in favor of the claimant, and it is held that the insurer would be liable for the compensation payable to the workman. The tribunal commissioner has determined to be entitled to sum rupees 4,15,960 by applying the correct income and the relevant factor. The award of compensation of rupees 4,15,960 is therefore performed, and the insurer will be able to pay the said sum along with interest at 12% from the expiry of 1 month from the date of the accident till the date of payment. Appeal is accordingly allowed. The reliance placed upon by the judgment rendered by the Apex Court in AR 2020 Supreme Court 454453 can be of no assistance, since in that case the Supreme Court was dealing with a case where it was not in dispute that the employer had not taken steps to ensure whether the license was renewed or not, and therefore the non-renewal of license had to be attributed to the employer. In the instant case, since the police have not charged the deceased workman with driving without a license, the said decision can have no application at all. ಏನ್ ಅಂಗಡಿ ಅವರೇ ನಮ್ ಕೊಡ್ತೀರಾ ನೀವು 3 ದಿನ ಲಯಬಿಲಿಟಿ ಎಕ್ಸಾನರೇಟ್ ಮಾಡಿದ್ರಲ್ವಾ ನಿಮ್ದು ಕಾಂಟ್ರಿಬ್ಯೂಟರಿ ನೆಗ್ಲಿಜೆನ್ಸ್. ನಾಳೆ ಬರ್ತೀರಾ? ನಾಳೆ ಟುಮಾರೋ ನೀವಿದ್ದೀರಾ? after tomorrow let them come. ಯಾರು ಬರ್ಬೇಕು?
ಸ್ವಾಮಿ ಸೀರಿಯಲ್ ನಂಬರ್ 10 ನಾಡೋದಕ್ಕೆ ಆಗ್ತದೆ ಸ್ವಾಮಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 10 ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಚ್ ನಾಡೋದಕ್ಕಾಗಿ. ಯಾಕೆ ಆಮೇಲೆ ಶಶಿಧರ್ ಅವ್ರ ಅಪರೆಂಟ್ ಇಯರ್ ಅಂತ ಸ್ವಾಮಿ, ನಾಟ್ ಫಾರ್ ರೆಸ್ಪಾನ್ಸ್. ಶಶಿಧರ್ ಅವ್ರ ಅಪರೆಂಟ್ ಇಯರ್ ಅಂತ ಕೇಳ್ಪಟ್ಟೆ ಸ್ವಾಮಿ.
ಶಶಿಧರ್ ಅಪೆಲೆಂಟ್ ಗ
ಹಾ ಅದೇ ಕೃಷ್ಣಾರೆಡ್ಡಿ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ಇವಾಗ ಯಾರ ಅಪೆಲೆಂಟ್ ಗೆ
ಶಶಿಧರ್ ಅವರು ಅಂತೆ.
to print the name of R. Shashidhara is appearing for appellant instead of R1 and R2.
ನಾಡ್ದಕ್ಕೆ ಹಾಕ್ಬಿಟ್ಟ ಸ್ವಾಮಿ.
ಇದೇನ್ ಕೇಸ್ ವಿಜಯ್ ಕುಮಾರ್?
ಇದು ಪೆಟಿಷನ್ ನಂದ ಸ್ವಾಮಿ ಈ ಕೇಸ್ ಅಲ್ಲ ಸ್ವಾಮಿ.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
ಆಯ್ತು ಮತ್ತೆ
ನಾಳೆ ಬೆಳಗ್ಗೆ ಹಾಕೊಳ್ತೀನಿ ನೋಡೋಣ, ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮುಗಿಸ್ತೀನಿ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ನಾಳೆ ಲಿಸ್ಟ್ ಆಗೋಗಿರುತ್ತಲ್ಲ, ನಾಳೆದಕ್ಕೆ ಬೇಕಾದ್ರೆ ಲಿಸ್ಟ್ ಮೀನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಹೌದಾ? ಯಾವ ವರ್ಷದ್ದು? 2011 ಮುಗಿಸ್ತಾ ಇದ್ದೀನಿ ನಾನು.
What up, sir? What up, sir?
ಹೇಳಿ ಸರ್.
ನಾ 3ನೇ ಕೋಟೆ ಸಿಗಾಕೊಂಡು ಬರಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ.
ಆಯ್ತು ಸರ್, ನಿಮ್ದು 2 ಆಯ್ತು.
ಅಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಏನಾಯ್ತು
ಸರ್? ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಪಾರ್ಟ್ಲಿ ಅಲೌಡ್, ನಿಮ್ದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಹಾ,
ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 6
4 ಒಂದಿತ್ತು.
4 ಪಾರ್ಟ್ಲಿ ಅಲೌಡ್ ಆಯ್ತದ.
ಹಾ,
ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಅದು 80% ಇದು ಅದು ಮಾಡಿದಾರೆ ಸರ್.
ಏನು
80% 20% ಅಂತ ಇತ್ತಲ್ವಾ ಅದು.
ಹಾ,
ಟು ರಿಕವರ್ 80% ಫ್ರಮ್ ಓನರ್ ಆಫ್ ದಿ ಇನ್ಶೂರ್ಡ್ ವೆಹಿಕಲ್ ಅಂತ ಏನೋ ಮಾಡಿದ್ದಾರೆ.
ಹಾ, ಹಾ.
ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 7 2 ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ.
2 ಡಿಸ್ಮಿಸ್ ಮಾಡಿರಾ? ಏನು ಓದ್ತೆ ಅಲ್ಲಿ 3ನೇ ಕೋರ್ಟಲ್ಲಿ ಒಂದಾದ್ಮೇಲೆ ಶುರು ಆಗೋದು. ಆಮೇಲೆ 12, 13 ಅದು
ನಾಡದ್ ಬರುತ್ತೆ ಸರ್, ನಾಡದ್ ಬರುತ್ತೆ. ಆಫ್ಟರ್ ಟುಮಾರೋ.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಒಂದಿತ್ತು.
ಯಾವ್ದು ಸರ್?
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 69 ಅಂತ.
69 ಅಲ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಸರ್, ದಸರಾ ವೆಕೇಶನ್.
ಇದು 29 ಅಲ್ಲಿ ಇದು ರಿವ್ಯೂ ಮಾಡಿದ್ರದಲ್ಲ.
ಹಾ ಸರ್,
ಅದೇನ ಪೇ ಅಂಡ್ ರಿಕವರಿ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಪೇ ಅಂಡ್ ರಿಕವರಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಶಾಮಣ್ಣಸ್ ಕೇಸ್ ಏನೋ ಅದ್ರಲ್ಲಿ.
ಅದಿಲ್ಲ, ಇದು ಮಾಡ್ಬೇಕು. ಫ್ರೀ ಕಾಪಿ ಕೊಡಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿದೀನಿ ಅಂತ
ಮಾಡಿದ್ದಾರೆ ಸರ್, ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲಿ ಕೇಳಿದ್ರೆ ಅವ್ರು ಇಲ್ಲ ನಮಗ್ ಗೊತ್ತಿಲ್ಲ.
ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ, ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಅದನ್ನ ಹೆಂಗ್ ಇದ್ ಮಾಡೋದು?
ಅಲ್ಲ ಆರ್ಡರ್ಲೆ ಬಂದ್ಬಿಟ್ಟಿದೆ ಸರ್. ಇದು ರಿಜಿಸ್ಟ್ರಿ ಡೈರೆಕ್ಟೆಡ್ ಟು ಇಶ್ಯೂ ಕರೆಕ್ಟೆಡ್ ಕಾಪಿ ಅಂತಾನೆ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ಅಲ್ಲೊಂದು ಮೆಮೊ ಹಾಕೋಬೇಕು ಏನೋ ಹೇಗೆ ಅಂತ, ಪ್ರೊಸೀಜರ್ ಏನು ಅಂತ.
ಅದು ಅಲ್ಲಿ ಇವ್ರಿಗೆ ಕಾಪಿಂಗ್ ಬ್ರಾಂಚ್ ಒಂದ್ಸತಿ
ಕಾಪಿಂಗ್ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಹಾಕೋಬೇಕು ಹೇಗೆ ಅಂತ.